I didn't know I'd be leading off today, but good afternoon, honored Chair Senator Flexer and Representative Blumenthal, and distinguished members of the Government Administration and Elections Committee. I'm Carrie Lynch, Climate and Energy Policy Manager at the Nature Conservancy. Thank you for the opportunity to present testimony today. We are supporting House Resolution number 8, a resolution recognizing that all land in Connecticut was once Native American territory. The Nature Conservancy supports the resolution, acknowledging that all land in Connecticut, treaty or unceded, was once Native American territory, and that these lands continue to be the ancestral homelands of the Mohegan, Mashantucket Pequot, Eastern Pequot, Schaghticoke, Golden Hill Pagosset, Nipmuc, and Lenape peoples. These peoples have inhabited and stewarded the lands and waters of Connecticut for generations, with wisdom and respect for the balance of the natural world. Acknowledging their names and histories is a small gesture of respect and a step towards correcting the stories and practices that erase the history and cultures of Indigenous peoples. As an organization committed to protecting the lands and waters that all life depends on, we honor Indigenous peoples and tribal communities for their strength and resilience, and we aspire to uphold our responsibilities according to their examples and traditions. We agree that acknowledgements like these, when coupled with authentic relationships and informed action, will help us move closer to deepening respectful relationships with all the people of this land as we search for true reconciliation from the impacts of colonialization. And with that, thank you for the opportunity to present testimony today in support of House Resolution number 8.
Thank you. Do we have any questions or comment from the committee? Seeing none, we thank you for being with us today and for contributing your testimony. Next up is Senator Heather Summers with us. Senator Bob Duff. Is Bob Duff here? No. Next up is Scott Gall. Scott Gall present. All right, Alex Knopp is here. Alex, whenever you're ready.
Thank you, Representative Blumenthal, Senator Flexer, members of the committee. I'm first want to say I had the privilege to chair the GAE committee for several years and appreciate all you do to protect our democracy. Today, I urge you to close a loophole in Connecticut finance law to prevent Connecticut from becoming one of the next fronts in Vladimir Putin's war against Western democracies by supporting Senate Bill 1188. And before I begin a little more detail, I want to thank Senator Flexer and Senator Sampson for their work last year at the end of the session to try to pass this bill. This bill is necessary because federal law prohibits foreign donations in all elections. But in 2021, the Federal Elections Commission determined that a state ballot referendum was not a, quote, election, unquote, and therefore there was no federal prohibition against foreign donations to influence the outcome of state ballot referenda. That case happened to involve whether an Australian mining company could participate and spend money to defeat a referendum issue in Montana regarding how mining was to be conducted. But the same would hold true for referenda elections. Now, Connecticut, as you know, does not allow statewide policy type referenda, but in 2024, we are likely to have one of the rare important state referenda, which is the question of whether the state should approve no excuse absentee balloting, just as last year we had the referenda about whether to have early voting. So there will be an important state referendum coming up next year, as I assume the legislature will pass this year or next year the additional vote on a constitutional resolution. And therefore, unless this loophole is closed in state law, there will be an opportunity for foreign sources to contribute funds. There was a state conference this past fall in which federal officials expressed a lot of concern about the possibility of Russian or other intervention through funding to try to disrupt our election system. Jan Easterly, the director of the Federal Cybersecurity and Infrastructure Security Agency, said that because of Russia's attack on the Ukraine and the U.S. effort to provide weapons to Ukraine to defend itself, that there was a sort of a heightened incentive for Russia to try to intervene and disrupt our elections. My only concern about the way Senate Bill 1188 has been drafted is that it includes a lot of provisions in addition to the closing of the loophole about foreign donations to state ballot elections. There are a lot of cleanup issues in that bill about the citizens' election system and other parts that I think Michael Brandy will be testifying about following me sometime today. I would urge the committee to focus just in this bill on the prohibition against foreign donations, and put the cleanup provisions about the Citizens Election Program and other campaign finance issues in a different bill. I think there's widespread support for the ban on foreign donations, but there are just questions about some of the other aspects of the bill. Even the State Elections Enforcement Commission testimony that will follow mine expresses uncertainty about why some of the provisions not about foreign donations are in the bill. So I would hope that you take the approach that Senator Flexer and Senator Sampson did at the end of last session, have a bill just on the ban of foreign donations, which has probably widespread bipartisan support, will help protect the integrity of our election system, and leave some of the other cleanup matters in the bill to some other vehicle. Thank you very much. I appreciate the chance to testify this morning.
Thank you. Are there questions or comments from the committee? All right. Well, thank you very much for your testimony. Very
Thank you, Matt.
helpful, and we appreciate you being with us.
Thank you.
Yeah. So next up, I believe Scott Gall is with us now, and then Shannon Keefe will be following.
Great. Thank you for your patience. Sorry for being late. We were trying to resolve some of the questions on this legislation in the hallway. Thank you to the chairs, vice chairs, ranking members of the GAE committee, and all the other members of the committee. My name is Scott Gall. I'm the Chief Data Officer for State of Connecticut at the Office of Policy and Management. I'm here to testify in support of SB 1186, which is an act concerning data governance and requests for public records involving the Connecticut Preschool through 20 Workforce Information Network. There are 4 sections to the bill. I'm going to describe the intent of each of them and why we feel that you should treat it favorably, and happy to answer any questions on any aspect of it. So there's 4 sections in the bill. The first 3, I think, are what I would characterize as fairly straightforward technical changes to address different loopholes or issues that we found in state statutes, trying to implement standardized policies for the use of data across executive branch agencies. The first gives us the ability to delegate responsibility to advisory boards that we felt needed to be added explicitly. Second section corrects a reference to the list of executive branch agencies, which is using an out-of-date list. So some agencies have not implemented some of these policies over the past several years. So we're trying to get the current list of agencies referenced here. And then the third section is a reporting requirement on legal issues and interagency data sharing that we provide to this committee. We believe the intent was for it to be a one-time reporting requirement. We've been doing it faithfully for the last 4 years and are asking for the removal unless you wish to keep receiving the report on an annual basis. So those are the first 3, which again, I hope are fairly straightforward changes, but happy to address any questions on them. The fourth is a proposed change to routing requests for public records that come to agencies that are part of the P20WIN system. P20WIN is our state's longitudinal data system, provides secure linkage of records across 11 different agencies. Oh, that's not the, okay, alarm, great. I was like, I thought I had time. What we want to do is balance 2 different things here that are hopefully not in conflict, but I think are shared interests. So one is the interest in transparency, accountability, open government. We want to make sure that government is transparent, responsive to requests for public records. And at the same time, we want to protect privacy, security, confidentiality for Connecticut residents, particularly as they have sensitive confidential information that's used by state agencies. You can think of school records, child welfare records, homelessness records, Medicaid records. These are the kinds of records that state agencies administer. And we want to make sure that those records are not inadvertently exposed through public records requests. And so the change here is to make sure that we can route requests for public records that come through a limited set of interagency agreements back to the agency that is the originator of those records. So you can think of it, if someone comes and there's a temporary interagency agreement between two agencies to look at educational outcomes for people that are justice involved youth, or whether you're looking at whether there's overlap between Medicaid and child welfare, that if that a request comes in for the records, that we route it back to the agency that is the originator of those records. That is what agencies want to see to be able to preserve privacy, security, confidentiality. We feel that this process should still be responsive to public records demands, and we're asking for consideration of this change. So I think that's the real bell, right? Okay. Thank you. That's it.
Thank you. There are other questions from committee. Representative Master Francesco.
Thank you, Mr. Chairman. Thank you so much for coming in. Would you mind elaborating a little bit on what the CP20 win is? I'm not too familiar with that.
Sure. So I can go in as much length as you want, but to give a brief summary, it's a state longitudinal data system. So most states have this. It is a way of providing linkage across agencies. I think the way you can think of the value of this is trying to get at when you want to understand program outcomes, or whether a program's effective, or whether it's serving the right population. That often involves linking records across different agencies. So a standard case is you're looking at transition from K-12 into the college system. How many people come out of schools and they're earning a degree in Connecticut, or how many people come out and they find an apprenticeship or work in the trades? Those are different agencies that maintain those records: education records, workforce records, higher ed records. And so in order to figure out the answer to those questions, are Connecticut K-12 students staying in state, we need to link the records across those agencies to get that. And P20 win is the state, it's under 10A 57G in statute. That's the system that sort of provides this.
Thank you. And through you, Mr. Chairman. So it's sharing information within the state agencies, correct?
Yes.
And is it mostly for education?
It's historically based out of education. The current statutory language, I might get wrong. It's education into the workforce and supportive services. So it's a holistic view at individuals as they go through, into workforce, higher education, reliance on benefits programs, et cetera.
And how is confidential information in that database protected?
So the one thing to note, there's not a single database for it, which is is a security measure. The protection is through a combination of interagency legal agreements, the actual secure systems that agencies use to share data. It's linked temporarily within, we have a data integration hub, it's the Department of Labor, but it's a mix of legal agreements, staff policies and procedures to ensure protection of the information, and then as much as possible, minimizing the storage of that information over time.
So would anyone within these departments be able to have access to that information?
No, it's restricted to it's a list of authorized users for this particular question. So
okay. All right. Thank you.
I can't see the data, so that's it.
Okay. Thank you for the clarification.
Sure.
That's it, Mr. Chairman.
Thank you, Representative. Next up is Senator Flexer.
Thank you, Mr. Chair. Good morning. Thank you for coming to testify today. I just have a couple of quick clarifying questions, but I do want to I want to thank you for your leadership in this area. I'm grateful of the work we've been able to do together around data management and your incredible work managing that, in particular over the last, I think, I'm not sure, COVID brain, it's hard to count the years anymore, but so I just wanted to get some clarity around this proposal with regard to the elimination of the report every year in Section 3, and just wondering, is there going to be another report that's submitted a different way? What's the thought process there?
We're asking for a repeal of it. If there's interest from any members of the committee or the legislature in the questions at hand on legal issues and interagency data sharing, we're very happy to sort of bring that to bear and answer that. I think this is just my understanding is the intent was for this to be a one-time report. So we did one sort of holistic analysis of the state, and every year we've just been kind of providing a fairly standard update to it. But again, the topic is part of my job description and statutes. It is something that is we're always welcome to dig into more. It just, and if there's value to the report, we can keep doing it. But it's
yeah, I just wonder what the replacement potentially is. Like, if you could tell me we do X every year and it's basically the same information, that would be helpful to know just sort of
Yeah.
what the replacement document might be.
Okay, sorry, that's thank you. That helps me to think that. So there's a couple of different things that address the same underlying question. So one is, again, to reinforce the importance of transparency, open government, we try and as much as possible post everything that we do to the OPM site. So every legal agreement, every change in this, that we try and keep that information available to Representative Mastro-Francesco's questions. We post all of this information. It's on the site so that anyone can understand what's being done. So that's all available through the OPM site. We do a state data plan every 2 years that contains much of the same information that's in this report, or in theory could. And we have a data and analysis technology advisory board that is convened through GAE very capably by Valentina over there. And that group also provides an advisory function to my role and to the state on these topics. And I think also can bring up consideration. That group can issue reports, recommendations, dig into things in more detail, kind of on an as needed basis. So I think that group has some of the authority as well.
Do they issue reports?
They have not as of yet, but they have the ability to.
Okay.
It's under, we're missing some appointments on the group, but it can, that's part of the statutory basis for the board.
Okay, I'd just be curious, if there's something we can point some people to. I really appreciate that you guys you're very transparent in your operations, and there's a lot of information, but sometimes when there's a lot of information, it's hard to get a quick summary. So thank you.
Understood.
Thank you very much. Thank you, Mr. Chair.
Thank you, Senator Flexer. Are there further questions or comments from the committee? I just had a quick question. Looking over the testimony on this bill, there was some testimony opposing it from members of the Freedom of Information Commission. And so the gravamen of their testimony seems to be essentially that they believe that provisions of the bill will cause delays or reduce the burden, or reduce the obligation, or lessen the obligation to promptly respond to FOI requests. So wondering if you could respond to that concern.
I think we are hopefully trying to work out these what I would characterize as differences in language, not differences in intent. Our stance is that it does not do those things, that we're not changing FOI as a law. We are changing how FOI requests get routed for sensitive information to ensure that that information is not inadvertently exposed. So we're not changing how the law works. We're not changing the requirements to respond to requests. We're not changing the timeline for it. We're just changing how those, to ensure that those requests are routed to the right party, and all the other aspects of the law would still stand. So, again, that's sort of my understanding, our stance on this. This is not undermining FOI in any fashion. It's just trying to balance the considerations for transparency with privacy and security for Connecticut residents.
Okay, and it sounds like you're prepared to continue to negotiate and talk about language to try to get it right.
Yes, absolutely. And through this process, it's been helpful, I think, consulting with the particularly FOI Commission on this. We've looked at best practices around the country. Every other state that has a similar type of approach recommends as a best practice taking this, what we have put into the legislation, which is to refer the request to another agency. That is, the federal government recommends that. Different states have utilized that too. And so that's what we are asking for, is if a request comes in and it's some other agency's records, that it go back to the agency that has originated the request. And I think that I think we are on the same page with the intent, and that is the sort of underlying approach. And hopefully that is reasonable.
All right. Well, we appreciate your commitment to do that and your testimony more generally. Seeing no further questions, we appreciate you being here.
Great. Thank you very much.
Next up is Shannon Keefe, followed by Lucy Dathan, Representative Lucy Dathan. Is Shannon here?
Hello.
Oh, sorry, missed you there. Whenever you're ready, you can begin your testimony.
Good morning, co-chairs Flexer and Blumenthal, vice chair Slappin, Moore and Bello, ranking members Sampson and Master Francesco, and distinguished committee members. I'm Shannon Keefe, the legal program director for the State Elections Enforcement Commission. Unfortunately, our executive director could not be here today. I'll keep my remarks brief and refer you to our more complete and detailed testimony that has been submitted. I'm also happy to answer any questions that you have. Before the committee today are two bills which we believe are significant improvement to our campaign finance schemes, and one with which we have some concerns. House Bill number 6864, an act concerning municipal campaign finance filings, is a common sense solution to save municipal resources by consolidating the filings into the system that the state has already invested so much to develop. This bill would make the commission the repository for all campaign finance statements in Connecticut and also require electronic registration at both the state and local level. Currently, candidates and candidate committees running at the local level, as well as the political committees spending at that local level, file with their local town clerks. A political committee that wants to spend on 4 municipalities must file its disclosure statements in each of those 4 municipalities. SEEK has the capacity to take on this role, and it would make the lives of town clerks across the state much easier. It would also make the lives of treasurers a lot easier because electronic registration and disclosure would become available to them. We've already run a pilot program for 20 towns, and that was very successful. A copy of the commission's report on the program may be found on our website, and the commission remains ready to begin the implementation of extending the program permanently to all 169 towns. Senate Bill 1188, an act concerning referenda, independent expenditures, and certain other political spending, contains some long overdue updates to the law and also offers some improvements that we believe will strengthen campaign finance law going forward. Highlights include the adoption of a ban on contributions and expenditures by foreign nationals, and an adjustment to the 1-year dismissal provision that would allow sufficient time for hearings to take place and also for matters involving foreign spending and independent expenditures to be resolved. These are the most complicated matters and the ones with the most problematic respondents. From a housekeeping perspective, it implements updates to the law regarding independent expenditure political committees to reflect rulings in U.S. Supreme Court and Second Circuit cases made in 2013 and 2014. Similarly, it fixes some attribution oversights on communications made in support of referendum. There are other conforming changes as well. These are not glamorous changes, but are ones that will make our campaign finance system more consistent internally and externally. Finally, with respect to House Bill 6865, an act concerning campaign finance reform regarding certain expenditures, this bill's a mystery to us. We're concerned because sometimes changes to the law can have unintended and potentially negative consequences for the CEP. Organization expenditures are one of the only ways party committees and certain political committees can financially assist publicly funded candidates. They are exceptions that were built carefully into the law to do the least harm while preserving the small dollar constituent supported nature of the program. One explicit provision allows such committees to spend money on events at which a candidate is present. This ensures that if these events were fundraising events, the candidate would be there to do the fundraising. The CEP was designed, after all, to promote grassroots contact between the candidates and their constituents, not to delegate that contact and the fundraising to party committees and PACs. When the CEP was passed in 2005, this was an important element of it. When the legislature changed the party candidate listing organization expenditure in Public Act 13180 to allow such advertisements to contain negative language, the legislature did not change the requirement.
Ma'am, your 3 minutes have elapsed. If you could summarize the remainder of your testimony, and then there may be questions after that.
Absolutely. The legislature did not change the requirement that the candidates do their own fundraising. In fact, it explicitly added the provision that such communication may not be a solicitation for or on behalf of a candidate committee. And without similar clarifications, we have to oppose this change to the law. I'll be happy to take any questions if you have them.
Thank you very much. Are there questions from the committee? Representative Hoxa?
Thank you, Mr. Chairman. Thank you for coming to testify, ma'am. My question to you is, do you have any data to show how, how many instances of, foreign nationals making contributions to CEP candidates, Citizens Election Program candidates? And would the law, as you want it changed through this bill, affect candidates running for statewide office, whether they're going through the citizens election program or not? Or would it be just something that affects candidates that are going through the citizens election program? And just to reemphasize the first part of my statement or my question, don't forget to give us, if you have some statistical information on how frequent, foreign contributions occur and what constitutes as a foreign contribution. Is it somebody that, is here like on a tourist visa? Is that what the data is showing, that it happens that way, or just foreign entities that aren't even in the United States somehow, making contributions? Thank you.
As far as data on what's currently happening in Connecticut, we don't have that because we don't have the language that requires that disclosure. Right now, under federal law, there is some foreign spending that is prohibited. And what this provision does is follow what other states have done in extending that out. So for example, it used to be that the foreign spending was prohibited for referendum. And what happened is the FEC issued a recent opinion that said that those provisions in the law that we had thought prevented the foreign nationals from making unlimited expenditures in referendum actually don't apply to referendum. So what this does is it brings the law that is on the federal level that did apply in Connecticut into Connecticut, expands it a bit to apply also to foreign corporations. And then it clarifies that, as it did before the FEC's decision, that the foreign spending should also be prohibited for referenda.
Thank you for that answer. And through you, Mr. Chair, that's all I have.
Thank you. Representative Carpino.
Thank you, Mr. Chair. Ma'am, I just want to clarify. I appreciate the intent, and I just want to make sure that we all understand what we're talking about. Would your goal be to limit donations to only those who are citizens, or is there a different donation? I just want to understand who we're talking about here that would be prohibited for making donations.
It's foreign citizens and foreign corporations, and those are defined in the statute, in the proposal, in the same way that the other states have defined them. And it's just basically saying that it's the US citizens and corporations that should be spending on the US elections.
And through you, Mr. Chair, I don't disagree with you. I just want to be very careful that we understand what this definition is going to encompass. So if somebody is here legally and is applying to be a citizen, would they be prohibited from donating? And if so, is there going to be a residency or a citizenship question on every form? Is that what you would like to see should this pass? Through you, sir.
No, with respect to citizens, it remains the same as it was. This is about foreign corporations and extending it. The citizens that can participate are defined right now by foreign law, and this brings it in exactly as it's happening in foreign law, but clarifies and takes it back to where those same limitations are extended out to referendum as well. So it basically brings back the protections that the FEC opinion got rid of. And then it adds limitations on foreign corporations. So it's not about changing the way it works for citizens, except for that it's taking it back and prohibiting people who wouldn't have been able to contribute to referenda because they're foreign nationals, and they will again be prohibited.
And one last question through you, Mr. Chairman, and I don't disagree. I'm just trying to understand the logistics of running an election. Are we actually going to be asking folks to check off a box that indicates that they are a citizen of the United States before they're allowed to contribute? And if so, is somebody actually going to be verifying that? And that is my last question, Mr. Chairman.
They are currently doing so on the contribution certification cards. That's part of the contribution certification that all contributors make. And no, we don't check into that or verify it. But we would if a complaint was filed with us, we would look into it further.
Thank you, Representative Carpino. Further questions or comments from the committee? I had a couple questions about your testimony regarding House Bill 6865. So first of all, you had questions or opposition to the aggregation provision, and it sounded like the primary opposition was or concern was with regard to reporting and whether the aggregation would be reported. Would a reporting requirement resolve concern for you?
Yes. Right now, if somebody called and asked if people were violating the law based on the going over the amount that they could see in the statute, we would have to advise them. The only way to find out would be to file a complaint that we would investigate. And I don't think that would be a very good result for the treasurer. So to just have it in the form that the aggregation paperwork had been done would alleviate that concern.
Okay, thank you for that answer. That's helpful. And I additionally wanted to ask you about your concerns about the definition of campaign event being changed. So with regard to whether the candidate themselves needs to be present or a candidate needs to be present. Why is it important in your view that the candidate physically be present at an event for it to qualify as a campaign event?
We're concerned about what this language does with respect to the requirement that the candidates do their own fundraising. And it's not clear from the way the language is drafted currently what's happening and why, and whether it's getting rid of that requirement. It could be read as it's currently drafted to be doing exactly that for fundraising events that are thrown by caucus leadership and party committees.
So I guess and what do you mean exactly by do their own fundraising?
So the CEP is a grassroots public financing program where the candidates are voluntarily participating in a program that is designed to encourage them to increase their communications with their constituents. They have to get a certain amount of small dollar donations from the people that are within their own districts, and they have to do it themselves. And that's a public support threshold before the public funds are released to them. And so the concern would be that if political committees and party committees can do the fundraising for the candidates aren't showing the support for themselves. And so this was something that we've actually had this discussion before with the legislature with respect to Public Act 13180 and the changes to the party candidate listing that was made in that. Our concern there was when they took out the language that said a party candidate listing can only be these things because they wanted to allow negative language. That meant that it could become a solicitation. And once the legislature understood that, the language was changed and they added in, provided that so the party candidate listing isn't a solicitation. A similar provision added to this language would reduce our concerns greatly.
Okay, that's sorry, describe the provision again one more time.
At the end of the party candidate listing definition, it says, provided such communications are not solicitations for the candidate. And so what you would say here would be provided that the events were not fundraising events for the candidate.
Okay. I understand your concerns. And I guess I would ask, currently candidates make solicitations for fundraising, but they don't make every solicitation directly. There's often cases where individuals will try to spread the word and ask other people to spread the word. And so it strikes me that that we are currently in a situation where not all of those solicitations are direct between the candidate and the individual contributor. And so given that that is not the exclusive method currently, and also given that, there are some districts where they're pretty compact and the candidate, it may be relatively easy for them to be at an event. There are other districts where, they may have 9 towns and someone may want to do an event in one town and, they may be knocking doors in another. So I guess, why is it so important for events that the candidate be physically present? Would it really be changing that much to allow someone to have campaign literature there, to have it be clear that it's a campaign event, but not having them physically present? Is your sole concern just that kind of direct communication?
Yeah, there's no problem with campaign literature that qualifies as the party candidate listings that can always be passed out by these committees. And they can either print it themselves and pay for it or pass out the candidates' literature. Passing out the literature is not the problem. We're just concerned about the fundraising aspect and that the candidates are doing their own fundraising and qualifying, meeting the public support thresholds themselves. And yes, a candidate committee can certainly have solicitors soliciting for them, but those solicitors would not be paying for an event unless it was a house party exception. They would not be paying for an event because that would be outside of what was allowable within the CEP. So this is a paid for event similarly. And our hope would be that we would maintain having the candidate present if there was fundraising going on.
Okay. Okay. Well, I think I take your position. I understand your concern is really isolated to the fundraising concern. I think, there are certain concerns related to, first of all, on the one hand, whether an event counts as a campaign event if the candidate is there, even if it's not meant to be a campaign event. And there's also concerns maybe about candidates, especially in districts that are geographically broad, who may have to be in multiple places at once. But I think I understand your concerns and be happy to talk with you more about these issues. I don't think I have further questions right now. I think Representative Mastrofrancesco does.
Thank you, Mr. Chairman. Thank you so much for your testimony. I just wanted to piggyback a little bit on what Representative Blumenthal mentioned about the candidates being there for an event. How would that affect somebody prepaying for an event doing an online contribution?
So this provision is about organization expenditures and how and whether the amount paid by the party committee or the political leadership or caucus committee gets attributed. So the money for the event itself, let's say it's $1,000, and right now they're fundraising for 3 candidates. All 3 candidates would be there, and it would be allocated. And it would be up to the committee how to allocate it, whether the committee was also benefiting. It might be divided by 4 and reported, or it might be just divided by the 3 of them and reported these expenditures. Right now, if the candidates weren't present, it wouldn't count as that type of organization expenditure. It doesn't mean that it's not any type of organization expenditure. So for example, if the candidates weren't there and they were passing out literature that qualified under the party candidate listing provision, then it would be that type of organization expenditure. And it wouldn't be a problem that the committee, that the candidate wasn't there.
Okay, thank you. I guess I just kind of go back to, in order to have an event and the expenditure, you need to raise money. So I guess I was just kind of bringing it back to that area. I do have a question for you though, on the part for foreign nationals donating. It's kind of similar right now during the CEP. A person cannot donate to a campaign if they work for a nonprofit, or their company has maybe a contract with the state of Connecticut. Is the thought process the same when it comes to foreign nationals donating?
Yeah, I think, yes, I think it's a concern with paying to play and preventing that. And you certainly don't want foreign entities coming in and paying to play. With the not-for-profits and the state contractors that you mentioned, it's only the principals that are prohibited or limited in their donations. It's not everybody that works for the companies. And similarly, the foreign national provisions are limited to only those leading the corporations and things. So just working for a foreign entity wouldn't cause you to be affected in how you can contribute unless you were one of the decision makers, the people that would be in the position to pay to play, basically.
Right. So would that count now for family members? So let me just go back to one question first. The definition of a foreign principal obviously would be somebody that is an undocumented person in the state of Connecticut. Would that be correct?
It's currently that now, yes, because that's how the federal law exists.
Okay.
Yeah.
So if someone here, they're here undocumented, can't make a donation, but somebody in their family is here legally and they are a citizen, would that donation be acceptable? Because I know, like with nonprofits, it's not only the person who can't make the donation, but neither can anybody of their family members living in the same household. So would that be the same when you talk about a foreign principal?
No. And again, it's only the family members of principals of state contractors, which is a very limited amount of people within any company that has a state contract that qualifies.
Okay, unless I'm understanding, excuse me, the law. I mean, I've had a situation even with my campaign where the member of the family worked for a nonprofit, and then that nonprofit had a contract with the state of Connecticut. So her donation was dismissed, including the entire family.
Right. So for the question about her contribution must have been whether she was a principal of that. And so a principal of a not-for-profit is just the equivalent of the CEO and the people that are actually involved in managing that state contract. It's not everybody that works for the state contractor.
Right. It's the principal
Right.
person, including their family members. Family members are not principals, but the person's married, they have a couple of kids. They would be excluded as well. And I'm assuming that same policy would be what's in effect now would be the same as what you're talking about here when you're talking about donations from foreign principals.
No, if somebody's a citizen and married to a non-citizen, the non-citizen can't contribute under the federal law and the citizen can. You don't lose your right to contribute based on being married. It's different with the state contractor provisions. And even with the state contractor provisions, it's only the minor children who are actually living in the household and the spouse.
Okay.
It's a very narrow definition of immediate family. As I know you have a much broader definition for spending of CEP funds on on family members and businesses owned by family members. But for purposes of the lobbyist and state contractor contribution limits, it's a very narrow definition of family.
Okay, and then just one quick follow-up question. In the definition now for a foreign principal, it says an individual who is not a citizen of the United States, a national of the United States, or a lawfully admitted or permanent resident. Are you referring to people here with a green card?
Yes, and that's how it is now. That's just bringing the federal law down into Connecticut law as well.
Okay. Thank you for answering my questions. Thank you, Mr. Chairman.
Thank you, Representative. Are there further questions or comments from the committee? Sorry, I just had one more clarifying question based on my line of questioning before. Just to be clear on the events provision, if there is a clarification that it doesn't, that there's not either solicitations or there's some sort of clarification that the candidate is doing their own solicitations or something like that, then that would resolve your objection or your concerns, rather?
Yes.
Okay, well, that's great. We'd be glad to continue to talk to you about that, and we appreciate your testimony.
Thank you. Thank you for your time.
Next up, we have is Lucy Dathan present? Not seeing that Representative Dathan. Next up, we have oh, one sec, sorry. Oh, he's right there. Next up, we have Senator Duff, followed by Daniel Menahan.
Good morning, everybody.
Good morning.
All right, good morning. Thank you. Thank you for letting me testify remotely. I was working here in Norwalk on some issues, and so I appreciate the opportunity to be able to testify to the GAE committee remotely. Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and distinguished members of the GAE committee. I'd like to thank you today for allowing me to submit testimony in support of two bills, Senate Bill 244 and Senate Bill 1191. The January 6, 2021 insurrection was an event unlike anything we have seen in the United States, a wholesale siege and attack on the United States Capitol by American citizens. Even during the American Civil War, this did not happen. Only once before, during the War of 1812, was the Capitol attacked like this, and that was by the British Army. Senate Bill 244 seeks to take Section 3 of the 14th Amendment of the United States Constitution and codify it into Connecticut state statute. If adopted, this section would bar anyone who previously swore an oath as an elected official or a member of a police department and is then convicted of insurrection or rebellion from standing for election in Connecticut. No one who has sought the destruction of our democracy should be allowed into a position where they can undermine the interworkings of our government. These people, once they serve the penalty handed down by a court, should be allowed to continue living their lives, but they cannot be allowed to run for election in this very entity which they sought to destroy. They would be able to undermine the government from inside. Unfortunately, on January 6th, there were numerous examples of state representatives and state senators, municipal police officers, and others around the country who took an oath to protect and defend the Constitution of the United States, who ignored and violated that oath. The second section of this bill seeks to address employment and adds the charge of sedition or seditious conspiracy as an additional exclusionary offense. In seditious conspiracy cases, prosecutors must prove that two or more people conspired to overthrow, put down, or to destroy by force the United States government or bring war against it, or that they plotted to use force to oppose the authority of the government or to block the execution of the law. This is no small charge. Again, this bill seeks to keep people who work to destroy the government from serving as an employee of the government they sought to destroy. The second bill that I'd like to testify in favor of today is Senate Bill 1191. You don't need to be a member of Generation Z to know what TikTok is. It's a social media app mostly used on smartphones. Its presence is everywhere, especially amongst our younger generations of our society. The Federal Bureau of Investigation has repeatedly pointed out the danger that this application poses to government entities because of allegations that the Chinese government and the Chinese Communist Party have been using the application to collect data on American citizens. The United States House of Representatives and the executive branch of the federal government have both banned this application from their respective government devices. As of this week, the United States Senate is considering a bipartisan bill that would give the president the power to ban TikTok in the United States. Connecticut government should follow suit with the House and the executive branch and ban it on state devices. TikTok is just the latest of alleged foreign controlled devices or applications that we have been warned about. Kaspersky Labs software has had allegations of giving the Russian Federation access to our computers, and Lenovo computers that we ourselves use in the Connecticut General Assembly has also been accused of being compromised by the Chinese government. It is important that our technology staff and state government are aware of and investigate the allegations, are talking to one another and being proactive about taking steps to protect our citizens' information and data from nefarious foreign actors. This is why Section 2 of the bill requires technology staffs within the executive, legislative, and judicial branches to talk, assess, and take action. They're required to work together to ensure the software, apps, and devices that state government using is safe. The bill is not directed at any one entity. The bill is aimed at protecting highly precious data that the state possesses. If a foreign actor is aimed to obtain data from our devices, they might have well stolen the device itself. In some respects, this might even be worse than physically stealing the device because you never know that the theft has taken place. I'd like to thank the committee for your time and ask that you give Senate Bills 244 and 1191 favorable reports. Look forward to working with you as these bills go through the process. Thank you, Mr. Chair.
Thank you, Mr. Majority Leader. Do we have questions from the committee? Representative Hoxha.
Thank you, Mr. Chairman, and through you, Senator Duff. In the state of Connecticut, what, in which branch or amongst which employees of the state of Connecticut are there government devices with the capability of downloading the TikTok app? Because I know that, like, I don't think I can download it on my CGA laptop, for example. Maybe I can, I don't know, but I certainly don't have it on my laptop. But in, like, what instance, in what instances do we have TikTok downloaded on government equipment? Can you name a few, please?
Yeah, thank you. I appreciate the question. We as legislators don't receive state phones. At least I don't anyway. But I know in the executive branch and maybe probably the judicial branch that state phones are provided to various employees where TikTok and others could be downloaded.
Understood.
And this wouldn't impact our personal phones, obviously, too.
Understood. And if I could just ask a quick follow-up question, Mr. Chair. The data that we have, insofar as, the Chinese government and the CCP, having access to people's data, what type of data is that? Is that like individualized data, or is that kind of like metadata where they're looking at trends and, information that's not necessarily revealing the identity of a particular individual, or that they can't, know who the identity of a particular individual is from looking at that data? Is it like metadata, or is it like data specific to like individuals or groups of people or organizations, et cetera, et cetera?
I think that's a great question. And, my answer is that, according to some reports, it's everything. So, it could be metadata, it could be individual data. Some of that has not been crystal clear as to what is gathered. And I think that some of that is more problematic because of the fact that it is unclear and what is potentially being shared with a foreign government. So it could be your own personal data based on what's on your phone or the state's phone, but it also could be something larger than that too. And I think that is some of the concern that we all have. And I might add that this bill is one that I've spoken to other legislators on a bipartisan basis. So, as we've seen in the federal government, this is not a partisan issue. This is one that I think both sides of the aisle recognize that we need to try and at least raise up for debate and tackle in some way, shape, or form.
Thank you for that, Senator. Yeah, I mean, I personally would agree with that. Yeah. I don't think, I don't trust, the Chinese government if they're the ones behind this app and or have the capability of, using it to, monitor us in any way, then, I'm totally against that. Especially when it comes to, them potentially having that capability on, government devices. So no, thank you for your testimony. That's all I have, Mr. Chair.
Thank you, Representative.
Thank you. Further questions from the committee? Representative Master-Francesco.
Thank you, Mr. Chairman. Thank you, Senator, for coming in today. And the thing with TikTok, I got to be honest with you, I'm kind of on the fence on it. I haven't really seen any proof that they are spying on citizens. Do you have any data besides the news outlets? Do we have any hard facts or anything to show that that is what's going on? Through you, Mr. Chairman.
Thank you. Thank you, Representative, for the question. The data is, I serve on the National Conference of State Legislatures Cyber Security Committee, and there have been a number of discussions around this and around information that comes to our apps, which is one of the reasons why I fought so hard last year for our online privacy bill, our data privacy bill, because of information that ends up going to various companies based on the apps that we all use. I think there has been some mixed information from the FBI and from others who say it is or it isn't. But we just heard from Chris Wray, who's the head of the FBI, speak to the United States Intelligence Committee the other day, who testified in the fact that yes, this is a problem, and this has been a problem and continues to be a problem. So outside of media reports, there has been testimony by the FBI and others who have stated that this is an issue, and that we need to make sure that we're on top of it. I also might add that the Pentagon has said that they want to remove TikTok from their apps because they view it as a national security threat. So there are media reports, but there's also been live testimony by high-ranking officials in our federal government.
Thank you for that answer. So, testimony, the FBI coming in or Pentagon. I mean, to me, that's not hard evidence, somebody's testimony. I was just curious if there was any data. Like, I know you've had conversations, but is there any hard data that I haven't seen? I just listen to people testify, listen to the news. To me, that's not absolute proof. Unfortunately, that's the way it is today in this country, is you don't know who to believe. In my opinion, the media is not like it used to be years ago. It's and this goes for both sides of the aisle. I'm not just picking on one party or another, but a lot of it just seems to be smoke and mirrors, creating fear. And I don't know. I don't know. But I don't believe that any government device or computer should have any apps on it that takes time away from your duties during the day, that you're on TikTok or you're on Facebook or you're on Twitter. That's my contention. The part about TikTok, I don't have any hard evidence or hard proof, but I don't believe any employee that's paid for by the taxpayers should be on their device that's owned by the state or the taxpayers, and they're on social media. So my question to you is,
can I follow up with that point?
Yeah, let me just ask you this one quick question: is why not include Twitter, Facebook, and all other social media? Through you, Mr. Chairman.
Thank you, Representative. The issue with TikTok has been because of who it's owned by and where that information goes to. I don't think anybody has, while I may have my own concerns with some of the other apps that are out there like Facebook and the data that they may use. And that's why we fought so hard for the data privacy bill, which does address some of the issues on data privacy with Facebook and Twitter and some other social media apps. The issue with TikTok, and why I think that's been singled out and more prominent, is because of what we've heard from high-ranking government officials and the other data about who they're owned by, where that information is going to, and who controls and possesses that data. So that's why they have been highlighted more than maybe some of the other ones have. But I would again say I believe you may have voted for it last year, but the data privacy bill that we have does address some of the other concerns on Facebook, Twitter, and others. And the other thing I would mention to you, based on your comments before the question, is that that's one of the reasons why I put in that other section of this bill, is for the 3 branches of government in Connecticut to work together to identify issues that on hardware and on software that may spring up, and that there should be a coordinated effort. They should be working together, that it shouldn't just be one of the executive branch and one of the legislative branch, but all 3 branches of government should be working together to ferret out any kind of threats that we might have. When I was chair of the Energy and Technology Committee, we actually put forward the very first cyber security threat assessment for our electrical grid. That was the first in the nation, and as a matter of fact, since that's happened, many other states have followed suit. We need to probably update it again at this point, but we should be taking these things very, very seriously, because we have hackers across the world and some inside our country who want to take down some of our systems, and we need to make sure that we as a government are doing everything we can to protect our constituents.
Thank you. So, your biggest concern really is more of a security issue, not so much employees are on during the day on social media. It's more of a security issue. In your opinion, is it only a security issue when it comes to government devices, or the general public, like on their personal devices? Through you.
Thank you. And that's why we passed the data privacy bill, and we'll continue to update that. There's some legislation this year, I know in the General Law Committee that continues to do that, and Senator Maroney and the committee, I know, is Representative D'Agostino, and the ranking members, I know, are working very hard on those issues in that committee. But for this, I think we should be, we can only look at government devices, and I think that's what's appropriate.
Okay, thank you. I have no further questions. Thank you, Mr. Chairman.
Thank you, Representative Mastrofrancesco. Representative Carpino, followed by Senator Sampson.
Thank you, Mr. Chairman. It's nice to see you, Senator. I just have again, this must be my day of technical questions for you. So using an analogy of most private employers have policies that prohibit certain types, or in some instances, particular programs or applications from being downloaded on their company devices. So looking at the state of Connecticut as an employer, do we need a law to do this, or is this something that we can do administratively? Because as time changes, there will be other programs or apps that don't belong on state equipment. And I would hate to have to come back and update a law each and every time. So I'm looking to see if we can do this in a more efficient manner than perhaps a statute in the General Assembly. Through you, Mr. Chairman.
Thank you. And I think that that's obviously a call for the legislature. It's a policymaking body, and it's a debate that we can certainly have. I would say that this is, again, this is important because I think there's a focus on TikTok, but I would say that if just look no further than the policy of the United States government, which is why they passed a ban on TikTok in the federal budget that was passed last year, that impacted all of the executive branch, and the United States House of Representatives passed it for their devices for the House Representative devices as well. Your point is well taken from a standpoint of coming back, which is why as I pointed out to the other Representative Mastrofrancesco, our ranking member, that why we have the other section of the bill that talks about identifying other threats, because of course there are going to be other threats that are out there. Let's have this the experts determine what those threats are, and they can take appropriate action. But this legislation prescribes the 3 branches of government working together, and at this point I don't know that is actually happening right now. So I think having that policy where the 3 branches of government need to work together on these threat assessments, I think makes all the sense in the world.
Thank you. And again, I don't disagree with you, but I would hope in 2023 that all three agencies are prohibiting non-essential workplace applications and programs from being downloaded on state devices. Thank you, Senator. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Senator Sampson.
Thank you, Mr. Chairman. Good to see you, Mr. Majority Leader. How are you? Good.
Thank you, Senator.
Yeah, so I just want to start by following up on some of the other comments about the TikTok situation. Personally, I'm very skeptical of their involvement in any sort of spying for a couple of reasons. Number one, I mean, I know that politicians on both sides of the aisle have brought this issue to national attention. But as hard as I look, I never seem to find any proof or any data on it. So I'd be very interested if you've got something from NCSL or something else that might be valuable to this committee that can help us ascertain one way or the another, more concretely that there's a real significant problem. I think that would be very, very helpful. And of course, I have concern about, people using various types of national news and that type of thing to promote a political agenda. And we live in a day and age where the news media is not exactly fair anymore. It seems like almost everybody's, picked a side, and there's some element of bias one way or the other. And you gotta keep that in mind when you're looking at the news. The other reason I've been skeptical of the TikTok situation is Apple. Apple is well known as a very, very staunch supporter of individual privacy. And you can't get your app on their devices without going through their screening process. And I know it's pretty significant. And I've been impressed with Apple over the years. I mean, there was one point where they even refused to allow the federal government access to a phone in a crime. And certainly people can debate whether that was a good idea or not, but they definitely defended their customers' privacy, which I think is important. So just without getting into the conversation any deeper, I'll ask if you'd be very kind to provide any information you have that might have led to your support of this bill, because I want us to make a correct decision, and I think that should be based on facts rather than hearsay kind of testimony.
Yep. Fair request.
Yep, excellent. So just speaking to that, the issue of the other bill, Senate Bill 244. I guess I have some concerns about this bill, mostly because of the way it's written. I think everyone on the committee would agree that certainly people that commit acts against the United States of America might be inclined to, or we might say it's a good idea to restrict them from holding public office. What concerns me is the language of this bill, which in Section 1, it doesn't say anything about a conviction or anything like that. It just says, if a person who holds or held any elective or appointed state or municipal office or serves or served as a sworn member of a municipality's police department and took an oath before entering upon the duties of such position to support the Constitution, engages in insurrection or rebellion. Can you just help me understand? I mean, are we limiting this to people who are convicted, or simply people that quote unquote engage in? Through you, Mr. Chairman.
Thank you, Senator, and thanks for your question. The information and the language of the bill is at least Section 1 is subsection A is basically the 14th Amendment to the United States Constitution, except for the fact that the add-in of a municipality's police department. But other than that, we just took the language from the United States Constitution, and the reason is because we thought that state courts should have the ability to prosecute as well as our federal courts.
Yeah, thank you very much for that answer. Yeah, I'll have to go back and take a look at that portion of the Constitution. I mean, it seems to me that a conviction would be required, especially in America. I mean, this is a country based on the rule of law. And I would just hope that we would make sure that we're very clear about the fact that we're talking about folks with a conviction. I mean, I took a look at your testimony, and I got to be honest, Senator, my concern about it more than anything is seems to me the continued politicization of that event on January 6th.
or would we include anyone that was present on that day, or simply people that were convicted of actually committing some sort of violent act? Through you again, Mr. Chairman.
Thank you, Senator. It's basically if you've been convicted. We have people who are who may have been convicted of a misdemeanor, and that doesn't really include unless you've taken an oath of office. But basically, we want to keep people out of our elected office in our government who were hell bent on overthrowing the government, who were hell bent on not certifying the 2020 election. So that's why that's the genesis of the bill.
Yeah, no, certainly. I mean, the thing about January 6th is I think that there is more and more information coming to light every day. I don't know if you have a reaction to Fox News and Tucker Carlson's recent shows where he's sharing a lot of video that was not shared by the the press or any politicians for that matter over the course of the last several years. So I'd be curious to hear what you think of that. And not to turn this into a zoo, but forgive me, I have grave concerns that the bill that is before us targeting January 6th is being done more for political purposes than for legitimate purposes of protecting, elected office from people that don't love the country. I think there's a lot of people that serve in elected office that don't care for this country. And maybe they exist on both sides of the political spectrum. But the test has got to be much stiffer, in my opinion, than engages in or were present at January 6th. Wouldn't you agree?
Well, Senator, we may have to agree to disagree here because, I will say that I've heard you quote the United States Constitution many times on the floor of the state Senate. And that, the language here is based on the United States Constitution. So I would take that as, something that we both view very seriously. And I would not question your motives on your disagreement with the bill. And that's why we have this public hearing. That's why we have the debate and ultimately see what happens with this legislation. But I will say that, for me personally, we got sworn in that day up at the state capitol, and we were sworn outside, if you remember, because of the pandemic. We had we all talked to each other. We had a great time, even though we were freezing outside. And then I remember driving home and then being home and witnessing firsthand what happened on that day live. So I don't need necessarily to see video of over and over again, though I have watched it over and over again, to see how disturbing that whole thing is. To in fact see the Civil War flag, the Confederate flag, walked through the United States Capitol, which never happened during the Civil War, except on January 6th of 2021. And I was an intern for United States Senator Chris Dodd when I was in college, and a lot of the places where people were, where they were going through, rifling through offices, where they were walking, where they were destroying property. I've been in those places personally. I used to give tours in those areas personally. So for me, this was not only as an American citizen and as a state legislator, majority leader, but I was, as somebody who worked there, I was deeply disturbed by what I saw on that day, and the fact that there were people there who were not willing to, they were trying to interrupt in a legitimate election. They're trying to decertify an election. Police officers were killed. They were chanting "Hang my Pence." So I don't want to go too far on this limb here, but this is why I feel so passionately about this piece of legislation, because we never want to see that happen again on any side. We never want to see that day happen again. But we don't want to see people infiltrate our state government, our municipal government, whether it's elective office, whether it's through being an employee of a state or municipal office. We don't want to see them be part of our government apparatus. And if they want to do something else, fine. They should not run, nor should they work for state or federal, state or local office.
Thank you, Mr. Majority Leader, and I appreciate the answer, although I don't know that you really answered my question, which was that we want to limit this to people who are convicted of treason or rebellion, and not just people that were present on that day. And because
nobody's getting banned if you're just present on that day. That's not what this legislation says.
Okay, well, I appreciate that, because I think what's coming out now is we're finding out that a lot of the news reports and a lot of the, forgive me for using this term, propaganda that was put out over the last couple of years is not true. In fact, you just mentioned that that police officers were killed, and we found out just recently that's not true. The fact of the matter is that there are no police officers killed in the January 6th insurrection. The 5 police officers subsequently died. 4 of them committed suicide, and some much later than January 6th. And 1 police officer that was alleged to have been killed at the scene, there's now video of him walking around perfectly well after he was supposedly murdered. So it's really hard for me to trust anyone about what happened on that day. My understanding is there's 40,000 some odd hours of videotape that I think the press is screening right now to find out really what happened. And it's quite clear that there were some violent actors there who did terrible things that they should be condemned for and they should do prison time for. But there are plenty of other people who, it appears, were invited into the building without any opposition whatsoever. And they look like sightseers on the video tape. I mean, I don't know if those people could be considered insurrectionists or not. So to me, it's very important to get this right. I mean, your testimony, I guess, is the thing that concerned me more than anything, because of your desire to kind of put January 6th up there with the Civil War and some other things like that. I mean, are you aware that other similar acts have happened through time? 1954, for example. Mr. Majority Leader, through you, Mr. Chairman.
I know 1954 existed. I'm not sure what you're referring to.
In 1954, Puerto Rican nationalists stormed the United States Capitol and opened fire with automatic weapons and killed 5 people. That was a riot. That was maybe an insurrection. As far as we know, on January 6th, they have not found a single firearm belonging to people who entered the building that day. Not a single one. And no one was murdered. You know, to me, the depiction of the story by the national media and the National Democrat Party, to me, does not match the evidence that is being revealed in recent days. And I think putting forth legislation that tries to perpetrate what I think is a myth, it concerns me. So if we're here for the purpose of doing legitimate policy to make sure that we protect the offices that we hold from people that are truly dangerous to our nation, then I'm with you 100%. And I would support the bill based on that. But I've got to know that that's where it's coming from. And it's not just a political ploy to keep January 6th as an active issue for the propaganda of the Democratic Party. And I'll just leave it right there, Mr. Chairman. And I look forward to having more conversation about this and fine tuning the bill so we know that we're actually addressing what could be a legitimate problem and it's not just politics. Thank you.
Further questions or comments from the committee? Senator Duff. Oh, sorry. I take it that this bill would cover individuals who attack the Capitol or our seat of government to try to overthrow it, regardless of their motives. So that would include, for instance, the 1954 incident that Senator Sampson mentioned.
Yes. They were convicted.
And I take it regardless. I don't know if this bill actually specifically mentions a conviction, but I take it that, as I understand it, under this bill, there would have to be an adjudication that the person actually participated in these actions, in insurrection or rebellion against the United States, or giving aid or comfort to the enemies of the United States, not simply that they were present at an event like January 6th.
Correct.
I have a further question, which is, I think I understand the answer as to why you put this language in here as to limiting it to individuals who previously taken an oath to support and defend the Constitution of the United States. But is there any reason in your mind, from a policy point of view, why we should limit this bill's scope to individuals, solely to individuals who have previously taken an oath to defend the Constitution? Wouldn't it make sense to include individuals generally who take up arms against the United States or otherwise participate in rebellion or insurrection?
Yeah, I would generally agree with that. I think the issue is because of our state constitution and then limiting somebody's ability and their right to vote, which is not the intention that we had. We've gone to great lengths in the state to ensure that people have the right to vote, and we want to keep that ability for people to have the right to vote. So we want to narrow this, which is why we took the language from the 14th Amendment.
I appreciate that. I guess I'll just make a statement, which is that, first of all, I appreciate the intent of the bill. I don't think individuals who've taken up arms against the United States or participated in rebellion or insurrection against the United States or given aid or comfort to enemies of the United States, regardless of their motives, should be in positions of public trust in the United States. And it's certainly not it wouldn't be unique. I had to represent, when I became a lawyer, in every state where I have so far, that I had not done that, and that it certainly has been judged constitutional. This is directly from the 14th Amendment, Section 3, as you indicated previously. I wanted to make a further comment, which is that I can't speak to the motives of every person who was there on January 6th, but we know that among that group, there were a significant number of people who engaged in violent activity with the intent to overthrow the government of the United States. We know that some of those individuals were seconds and feet away from a situation where they could have done violent harm to the Vice President of the United States and members of Congress from both parties and of both bodies. And every individual who is accused of having done something wrong involved with that event or any other event has the right to defend themselves, both in a court of law and the court of public opinion. But I don't think we should ever underestimate the seriousness of what happened that day. It did constitute an attempt to overthrow the government. There were individuals there who engaged in violence against police officers and other individuals. And I don't think we should ever discount the seriousness of the actions of some of those individuals that day. And with that, are there any further questions or comments from the committee? Seeing none, thank you for being with us today, Senator Duff.
Thank you to the committee. Appreciate it. Have a good day.
Next up is Daniel Manahan present. I believe he's joining us by Zoom, and I see him. Mr. Manahan, whenever you're ready, you may proceed.
Wikisuck, good day. My name is Daniel Manahan. I'm a member of the Bashantucket Pequot Tribal Council, and I'm currently serving my third term. I'm accompanied by Rashad Young, who is a tribal member, community leader, and member of our Cultural Resource Department. And in addition to that, I currently chair the tribe's Historic and Cultural Preservation Committee, and I have been doing so since 2016. We are both here on behalf of the Mashantucket Pequot Tribal Nation, and we do want to thank you for your opportunity, time, and consideration. We are here in support of two bills on your agenda. House Resolution number 8, a resolution recognizing that all land in Connecticut was once Native American territory. And the second bill is House Bill 6077, an act establishing a process for addition of diverse statues for the state capitol building and establishing a state historical commission. Like I said, I wanted to actually thank you for those that are sponsoring the bill for their work within the state, specifically to these two bills. As far as the House Bill 6077, we are in agreement with the committee and the bill's co-sponsors to make the amendments to the existing mandate for the State Commission on Capital Preservation and Restoration to revise the scope of its master plan to explore more diverse statues for Connecticut's state capital. And with that said, the ability to have more of a diverse collection of statues, and we'd love to actually see some Native representation. Last time I went to the state capitol, going through the hallways, I actually noticed that there was one image of a Native American. And sadly, this image was from a Native American from Virginia. So with the Native population here in Connecticut, and those of us that actually descend from the original people here of Connecticut, it should be very easy to actually have imagery amongst the tribes and within this area rather than representation outside of the state. So that's one area where there's some room for more inclusion. So like I said, we are in support of the bill. One thing that I would ask is if the state is to establish a new state historic commission, I would ask for the state to have consideration of including the tribal historic preservation offices from the tribal nations within the state of Connecticut. Those state recognized and those as federal recognized tribes as well. So just a recommendation. As far as the statues, I was actually gonna share my time with Rashad Young, who is a representative of our Cultural Resource Department, as well as a young tribal member.
Yiki Sakwami, Natasluis Rashad.
I'm sorry to interrupt. So technically your time has elapsed, but I just wanted to note that and then ask you the question of what was your additional testimony?
My additional testimony, I was actually going to ask if I could share my time with tribal member Rashad Young, just to actually touch on the importance of the diversity within the state statues.
Mr. Young can continue whenever he's ready. And I'm essentially asking him to give his testimony.
Oh, okay.
I'm sorry.
Thank you to the administration and the committee for having me on, and thank you to Danny for sharing his time with me. I'm a member of the Cultural Resource Department and Language Department here at Mashantucket. And I just wanted to make a point that, like Danny said, there aren't many representations of the indigenous peoples of Connecticut there or in many places around the state. However, there is a depiction on the state building of the Pequot War, which was the first conflict, major conflict between indigenous peoples in New England and the English at the time, which became Connecticut and Massachusetts and New England and America. So the depiction that's shown is of the war. There aren't many of our people, and there are depictions of our people, primary sources from the 17th century that would be beautiful to be used for people to see as statues that could instill pride in people in my community and also give history to citizens of Connecticut, who a lot of them don't even realize much about, the indigenous people here in the state. So thank you.
Thank you, sir. Are there any other questions or comments from the committee? Seeing none, we thank you for being with us today and contributing your testimony. Let's see. Next up is Anna Shagru, followed by Paula Perlman.
Good afternoon, Senator Flexer, Representative Blumenthal, Senator Sampson, and honorable members of the GAE committee. My name is Anna Shagru, and I am speaking today on behalf of the Northeastern Connecticut Council of Governments, where I currently serve as a regional planner. I'm here today to express our support for Senate Bill 1190, an act concerning regional election advisors and a task force on election administration in municipalities. I have submitted written testimony and will therefore summarize it today. SB 1190 would transform the current regional election monitor, otherwise known as a REM, from a person who represents, consults with, and acts on behalf of the Secretary of State to what the bill calls a regional election advisor that works for a participating COG to assist its member towns with election-related issues, still in a fully coordinated manner with the Secretary of State. This change is directly reflective of what our REM has provided, which is advisory assistance to our town election officials to better enable them to do their jobs. Since 2016, when the REM was established, NECOG has found them to be a valued asset for our towns leading up to, during, and after elections, and most recently during reapportionment for state, house, and Senate districts in our region. Currently, we are one of 3 COGs that have maintained this position and have done so using our own funds. This bill would take away the mandate of hiring a REM, enabling the COGs with freedom to choose whether or not they would like to utilize their services. Our smaller towns need this service, as often the 4 seats, 2 registrars of voters and 2 deputies, are not filled. SB 1190 also establishes a special task force to, as the bill states, study means of ensuring that election administration in each municipality is fully staffed by personnel properly trained in all tasks necessary for effective election administration. This is especially important to our 16 member towns, as they are each confronting growing challenges to staff their election responsibilities. Much of our smaller towns cannot fund, staff, or succeed at the tasks that larger towns can handle. Thus, this study will be useful at examining how shared and regional approaches may be applied to the mechanics of local elections to make their administration more efficient and cost-effective. The intent of this study is to be exploratory, not prescriptive, but with this being said, we believe that the work of a proposed task force is especially timely in advance of the 2024 election, which will be a presidential election year, adding to the complications and stresses for our local election officials. Thank you for the opportunity to testify today, and I would be pleased to answer any questions that you may have.
Thank you. Are there questions here? There are questions from the committee. Senator Flexer.
Thank you, Mr. Chair, and good afternoon. Thank you for your testimony, and thank you to you and your colleagues for working with the committee on this proposal. I just wondered if you could speak to, I know in Northeastern Connecticut, there has been a real challenge, as you talked about in your testimony, with filling all of the registrar positions in particular in many of the smaller communities in our region. There have been situations in some communities where there's only 1 registrar, let alone 2 or 2 deputies. And it's been a real challenge to get someone to step up from each party to fill these roles. And the regional election monitor, it's my understanding from NECOG, has stepped up to sort of mentor folks into that role and make sure they are familiar with all of the priorities of the office. I mean, we have this system in Connecticut that has many benefits of the fact that it's so decentralized. And I think it's one of the reasons people can have great confidence in our system, but you also face these challenges of being able to staff it and make sure people feel like they've been given the knowledge they need to do their job well. So I wonder if you could just talk about some of those challenges we've seen in our region.
Yeah, so like you've said, our REM has really been useful for helping people transition into their registrar roles, especially if they hadn't had all of the training that they may have needed to perform that role correctly and efficiently. Our REM has really enhanced collaboration at all different levels, especially with the Secretary of State. And he was specifically very important for us when reapportionment was occurring. This was a difficult challenge for us because of our low staffing, and also because this perhaps isn't an issue faced by larger towns. So he was able to help us look at the map that was showing the makeup of the Senate district and some House districts and make corrections, working with local registrars almost on a house-to-house basis. So those are some of the issues that we had faced previously.
Thank you. Thank you for mentioning that. I think members of the committee will know that we have had issues in some districts where lines have been drawn incorrectly at the local level, and people in some of the districts that we represent thought they were in one district, but they were in fact in another. And so this position, at least in our region, has been used to make sure that kind of error, as the legislative redistricting maps move their way through the process, that those kinds of errors don't happen. And I think this is a resource that could be used well in other parts of the state, but I understand that this proposal makes it so this position is no longer mandatory. Can you just speak to that?
Yeah, that's right. So when it was implemented in 2016 and over the years that it had continued, we had found that only 2 other COGs, River COG and CROG, were actually utilizing this service. So we would change it to make it enabling instead of mandatory, just because of that fact, because some larger areas may not have these staffing shortages that we did. So they may not need those services.
Okay, thank you. Are there any other questions or comments from members of the committee? Seeing none, thank you very much for your time and your testimony today. Next, we will hear from Paula Perlman, who will be followed by Representative Bumgardner, who will be followed by Senator Fazio. Paula, welcome. The floor is yours.
Good afternoon, Senator Flexer, Senator Sampson, Representative Master Francesco, and distinguished members of the GAE committee. My name is Paula Perlman. I'm a staff attorney with the Freedom of Information Commission. I'm here today to testify in testify Section 4 of Senate Bill 1186, which concerns requests for records involving the Connecticut Preschool through 20 and Workforce Information Network and records shared among these participating agencies who have entered into a sharing agreement. The Commission believes that the proposal as currently written may impact the timely processing of requests and delay access to records of public interest. We believe a better approach would be to build into the proposal an explicit requirement that the actual agency receiving the request refer the request to the originating agency so that the latter agency can respond directly to the request. We also suggest that the agency making the referral be required to notify the requester that the request was referred to the originating agency, that a response to the request will be issued directly from the originating agency, and provide the requester with contact information of the originating agency as well as the date on which the referral was made. In addition, the Commission recommends that the proposal include a timeframe by when the referral must be made. For example, include a requirement that the referral must be made within 24 hours and no later than 48 hours of the receipt of the request. As Scott Gall testified earlier, we are working together to see if we can come up with some language that will capture the intent of the bill, as well as ensure transparency and government accountability. Thank you, and I'd be happy to answer any questions.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Just one quick question. I know you're working to have the language changed. Is it because right now it is not going directly to the agency, the request is not going directly to the proper agency, and it's going to hold it up? I'm just trying to
In
understand.
general, like the
because-
broader picture, we are concerned that an individual making a request to one agency is going to be sent to another agency, like that the agency receiving the request will say, well, these records originated from this other agency, you have to go there. So we feel like right there's a little bit of an obstacle, but in talking with OPM, we understand what the concerns are in terms of, maybe there will be confidential records that may be inadvertently disclosed. So we're okay with doing this referral process, but we just want to make sure that there's steps built in that, that the individual making the request knows that the request was made. That their request is being sent over to a different agency.
Who's on first?
Yeah, exactly. That so it's built into the language that we received your request. These records originated from another agency. So we think they should be required to say, reach out to that other agency and say, we've received this request. Please respond to it because these records originated from your agency. And at the same time, tell the requester, we acknowledge your request, but these records originated from this other agency. We have now reached out to that agency and they're the ones that are going to respond to your request. So there are a lot of steps being required because right now, if someone makes a request for records, it's that agency who now has custody of those records that has to respond. So they're the responsible agency. But what the proposal is requiring, well, it's saying that, okay, you've made a request to us, but really those records originated from that other agency. You have to go elsewhere to get the records.
Okay, and you want it to stay at where it was requested originally.
Well, what we're saying is if you're going to do this, then there should be some more accountability on the agency that received it to work with the requester so that the requester understands that they should be going to the other agency, why they should be going to the other agency, and to keep them looped in the process, really.
And it would go to the person requesting to an agency. It goes there because they just sent it to the wrong agency, not knowing where it should originate from. How does that happen?
So I think the requester would make, for instance, Department of Labor is one of the agencies that have signed onto this sharing agreement. So the requester believes that they can get these records from the department. This is our understanding of how this, what they're proposing. The requester makes, believes that the records are with the Department of Labor. They made the request to the Department of Labor. The Department of Labor under this proposal would say to the requester, some of these records that we have that would be responsive to your request came from a different agency, and they would be the ones that now should respond to it. So please go to that agency to get those records. Currently under FOI, it's the Department of Labor that would have to respond completely. If they have those records, then they have to provide them unless there's some exemption that applies. What we're proposing is if you're going to make that referral, you work with the requester so that they understand what's happening so that they can follow it. Basically, this request has been made. We're going to refer to the other agency. This is when it was made. So you may want to follow up with them so that the requester is not lost in all of this, that they understand what's happening.
Got it.
Because if they're not involved in the process, what's going to happen is DOL may take some time to respond to the requester and then eventually tell them, oh, wait, it's really these records are with this other agency. You got to go to that agency now.
Got it.
And so then the requester, then will have to, then they go to Department of, I think, in other words, like Office of Higher Education. And it goes to Office of Higher Education. And they said, okay, we got your request, but it's going to take us some time to respond. So it seemed like it might just delay the process.
Yes.
So that's our
Yeah.
concern.
I get it. It almost
proposal.
reminds me when you're trying to make a phone call and you're on hold, or they keep transferring you to different departments. And when you finally get to the department, they're like, oh no, this is the wrong company, or this is the wrong department. It's frustrating. It's not a smooth.
Yeah. So we're not
process.
necessarily saying don't do the referral, but you just have some more safeguards built in so that the request doesn't get lost.
Got it.
And then there's more delays.
Okay, I understand now. Thank you so much. I appreciate your testimony. Thank you, Madam Chair.
Thank you, Representative. Seeing no further questions or comments, thank you again for your time and your testimony this afternoon.
Thank you.
Have a nice weekend. Next, we will hear from Representative Andre Baumgartner, who will be followed by Senator Ryan Fazio, who will be followed by Jenna Grande or Grand. Representative Baumgartner, welcome. The floor is yours.
Want to speak on actually 5 pieces of legislation today. First, in support of HB number 5720, an act reestablishing the Legislative Program Review and Investigations Committee. The Bipartisan Legislative Program Review and Investigations Committee was established by statute in 1972 and eliminated after the 2017 bipartisan budget. The committee's main charge was to review and audit state agency programs for efficiency, effectiveness, performance, and compliance. Assisting the committee was an office of specifically dedicated full-time professional, nonpartisan staff, which was closed in January 2017. Here's a real solution. The Connecticut General Assembly should recommission the bipartisan/nonpartisan Legislative Program Review and Investigations Committee to audit state agency programs for efficiency, effectiveness, performance, and compliance. Unlike in Washington, D.C., where the Oversight Committee functions as the most polarized and partisan committee in Congress, we can have a committee that ensures a transparency and accountability in our state government. Here's an idea to take the politics out of the picture. Restore the PRI committee in its original form by requiring an equally bipartisan 12-member panel, 3 Senate Democrats, 3 Senate Republicans, 3 House Democrats, or 3 House Republicans in order to approve study reports on state programs and investigative issues. You can even make it a 16, 20, 24-member committee, but it should still have an equal membership amongst both chambers and parties. With all the talk in my corner of the state about state peer, some school construction programs, and calls for greater legislative oversight of various quasi-public agencies, it seems like a logical next best step to reestablish this now defunct committee in the spirit of bipartisanship. I'd also like to speak in favor of HR number 8, resolution recognizing that all land in Connecticut was once Native American territory. We respectfully acknowledge that this public hearing is, or I should say, this event is taking place on the traditional territory of Pequot Tribal Nation or Mohegan Tribal Nation. I've made it a point to use those exact words at various events as I speak in my official capacity as a legislator in my neck of the woods in southeastern Connecticut. It is long overdue that in the legislative sessions, public meetings, and when we attend functions in an official capacity, that we offer land acknowledgements of the ancestral territories of the Eastern Pequot, Golden Hill Pagaset, Mashantucket Pequot, Mohegan, and Schaghticoke tribal nations and other historic tribal nations indigenous to our state. HB number 6077, an act establishing a process for the addition of diverse statutes to the state capitol building and establishing a state historical commission. I speak in favor of this legislation. As a Mashantucket Pequot Tribal Nation Councilor Daniel Menahan noted in his testimony, the Pequot tribe has occupied southeastern Connecticut for more than 10,000 years and had approximately 8,000 members and inhabited 250 square miles of our territory. So I will be submitting a written testimony, kind of speaking to why this is so important and long overdue, and happy to answer any questions this committee may have. Thank you.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony. Have a nice weekend, Representative. Next, we will hear from Senator Fazio, followed by Jenna Grand, followed by Evelise Correa. Senator Fazio, welcome. The floor is yours.
Chairs Flexer and Blumenthal, ranking members Sampson and Master Francesco, I appreciate the opportunity to submit testimony in support of SB 1191, an act prohibiting the use of certain applications, software, and programs on state government devices and requiring minimum security standards and annual audits of such devices. I came up with a catchy title myself. Just this week, the FBI reiterated its warnings on the dangers that foreign controlled applications and devices, most notably the social media application TikTok, poses on government entities and their data security. Our state is better safe than sorry when it comes to protecting the privacy and data of our state employees and state assets. Already, 25 other states have banned the use of TikTok on state devices, and the federal government has done the same due to security concerns. Connecticut should join them. We know that ByteDance, the parent company of TikTok, staffers have used the technology to surveil US-based journalists whom they suspected might be speaking to employees of the company here in the US. They're able to do that through geolocation because TikTok and other apps are able to track the location of the user. No company in the world is able to collect as much data from individuals as ByteDance, the parent company of TikTok, with its close association with the Chinese government. The data could be used in numerous ways, including to profile and target different populations to the ends of the company or its regulators or its stakeholders. Data that is compromising on a state or federal government employee could also be valuable to a foreign government. We are a bit in the dark about the capabilities of TikTok and its parent company and the Chinese government given, but it is reasonable to believe that it can be significant. While individual and recreational use of such social media applications is well beyond our purview, as a state government, we do have an obligation to our state to protect often sensitive data and non-public information found on state devices. I'd like to thank the committee for its consideration and would be willing to take any questions. Thank you.
Thank you. Thank you, Senator. Are there any questions or comments from members of the committee? Representative. I'm getting a no.
I won't be offended if you don't have any questions.
I thought I was getting a no, Senator. Don't blame me. Senator Sampson.
Thank you, Madam Chairman. Good to see you, Senator. It's not so much that I don't want to speak with you. I just don't know that I have a whole lot to ask, other than the same thing that I asked Senator Duff when he came to testify on the same bill, which is certainly, obviously, if there is some sort of legitimate threat to the United States posed by this application on various devices, obviously we should do something about it. I keep reading lots and lots of press and I see there's warnings and the FBI says this and that, but I've never seen anything that they actually concretely say is the problem. And I'm a freedom guy, as you know, Senator, so I want to make sure that we're being fair about this. I also been looking at trying to find out if Apple or Alphabet have had any comments on the subject, because I know they've been asked numerous times by the FCC and judicial authorities too to consider removing the app. I'm just wondering if you've heard of any concrete evidence. I'm not suggesting that there isn't any or that we should doubt these folks, but if you've got anything more that you might add about real information or a source that we could go look to as a committee to help find it,
yes,
that would be appreciated.
Well, I think one of the best examples is that 4 employees of ByteDance use TikTok data, the geolocation data specifically, to track US journalists whom they suspected were speaking to employees of TikTok here in the US. The ability of these applications to retain and collect data is immense. And really, if you want to drill down into the data, you can figure out what individual person you're tracking, because of the geolocation, because of the tag to an individual phone or IP address. And then on top of the geolocation, you're also collecting data about what the person views, what the person's tastes are, et cetera. And that also has immense power. As far as the general public goes, we're not advocating to ban TikTok, on private phones in the state of Connecticut. I think that would be an abrogation of people's personal liberties if there isn't a really, really significant security concern. This is just for state devices, state devices of state employees, which could have information and access to important state information. And I think it's better safe than sorry on that front. It also raises the question, does a state device need TikTok on it in the first place? And so I think the benefit of the doubt doesn't go to allowing the app on the device in this case. If it was private actors, then absolutely, the benefit of the doubt more than goes to allowing it. But in this case, state devices, we do have examples of nefarious actors on their side, and there's probably a lot more that we don't know.
Through Mr. Chairman, thank you very much for that, Senator. I couldn't agree more with your statement, and that certainly is a different story. Obviously, I don't see a reason to have state property, certainly devices like phones and computers having social media accounts, and they're legitimately needed for the position that that person holds in our state government. So that makes perfect sense. And I'm in complete agreement. And I also agree with better safe than sorry. And we're not interfering with the rights of individuals. So I'm with you on that and look forward to hearing more about this bill going forward. Thank you, Madam Chairman.
Thank you, Senator. Representative Mastro Francesco.
Thank you, Madam Chair. Thank you, Senator. It's nice to see you. Thank you for your testimony. I just had a quick follow-up question. You had mentioned to Senator Sampson that the tracking on TikTok, they're tracking people's behaviors, what they like and what they don't like. Who did you say you got that data from?
Well, that is something that any company would acknowledge that they're able to do. That is data that they have. The specific example of the four were that there were 4 employees of ByteDance who actually went into, an individual IP address, tracked their geolocation, because you can tell through the apps. And this is not just true for TikTok. If you go on your phone, any number of the apps have geolocation on them, and you would have to opt out of it. But those are retained mostly by private companies that we do not suspect have a very close relationship with the Chinese government. And so we know that the apps, like a lot of these apps, are able to track geolocation and other data. But the specific example was reported in the news of 4 employees who use the data in order to surveil US journalists. And that's an example of what, just by virtue of what the company does and how much data it collects, it would be able to do in spades constantly.
Gotcha. Okay. Yeah. Listen, it's obviously a concern. People tracking you, even the United States government. I mean, there's apps out there that, like you say, they track your behavior, they track your data, they have all this information. So I understand the concern. As I said to Senator Duff, my concern is, I don't know if there's really any solid proof, because people are tracking everything these days. I don't like to see any of those apps, Facebook, any social media on any federal device or any state device when people are working during the hours. That really is my concern, opposed to the other one, until I get a little bit more information. But I understand your concern. Thank you so much.
Thank you,
coming.
Representative.
I appreciate it. Thank you.
Thank you, Representative. Are there any additional comments or questions? Representative Hoxha.
Hoxha, that's all right. Thank you, Madam Chair and Mr. Chair, and through one of you or both of you. Thank you, Senator Fazio, for appearing before us to testify. I am in favor of the bill. My only question is, I just want to, give you an opportunity to, kind of, really clarify, the spirit of this bill, which, if I'm not mistaken, is to really just make a distinction between TikTok and other social media platforms, insofar as to really kind of allow people to understand that one potentially, or does, as a matter of fact, have ties to a foreign government that is at the very least adversarial to the United States. Whereas Facebook, Apple, and some of these other American-based companies are American-based companies, and thus, are not in that same category. Correct me if I'm wrong in saying that is really kind of the spirit of this bill, is to make that distinction, that, TikTok isn't necessarily entitled to the same sort of treatment by the government as some other American-based companies, because of the fact that their parent company ByteDance has clear ties to the Chinese government.
Yeah, and I believe like ByteDance, for instance, its editor-in-chief of content is a secretary in the Chinese Communist Party, for example. This, again, is supposed to be better safe than sorry. It's state devices. We as a state government have a lot of flexibility in determining how we use our state assets and our state devices and our state data and who we want to give it access to, whom we want to give it access. And it strikes me as common sense protection on privacy of state employees, but also on the security of our data, that we go down this road of removing the ability to download this application in particular from state devices. And that's exactly why the federal government did it for federal employees, and 25 other states did it for their state employees. So I think it's a better safe than sorry policy.
Totally agree. Thank you very much for that.
Thank you, Representative.
Mr. Chairman. Thank you.
Thank you, Representative. Representative Blumenthal.
Thank you, Madam Chair, and good to see you, Senator Fazio.
Good to see us.
I appreciate the bipartisan conversation we're having about this bill. I think, every day it seems like we learn more about the capability of companies, technology companies, especially social media companies, to gather data on us through our phones. And quite frankly, it's disturbing. The more we learn, I think in the past, a number of social media companies have misrepresented to the public what kind of data they collect and how they use it. While I hope that we're able to pursue broad-based legislation to the extent we can at the state level to try to protect the privacy of the people of Connecticut in that regard, certainly a company that can gather that data that is a foreign entity and one of our global competitors is one we should be especially skeptical about. And I can think of all manner of situations where the kind of information that TikTok and ByteDance are able to gather on Connecticut employees would be useful to them. And so I appreciate you and others who have brought this bill to us. It's a conversation I think that is worth having, that we need to have, and I'm glad we're having today.
Thank you, Mr. Chairman. Appreciate those comments.
Thank you, Madam Chair.
Thank you, Representative. And thank you again, Senator, for your time and your testimony this afternoon. We hope you have a nice weekend.
Thank you, Madam Chair. You too.
Next, we will hear from Jenna Grand, and correct me if I'm saying your name wrong, Jenna, and then we will hear from Evelise Correa, followed by Anna Posniak. Jenna, welcome. The floor is yours.
Thank you so much, Chairpersons Flexer and Blumenthal, and members of the committee. Thank you for the opportunity to appear today. My name is Jenna Grandy, and I'm here to support SB 244. Born and raised in Branford, I've always been proud of our state's policies to safeguard our democracy. I got my start in politics and public service right here in Connecticut. I interned for Senator Richard Blumenthal while in college, served as a campaign manager for now Comptroller Sean Scanlon's first campaign for the General Assembly, and was the Planning and Development Committee clerk for this body in 2015. Today, I am the press secretary at Citizens for Responsibility and Ethics in Washington, a nonpartisan nonprofit committed to government ethics, transparency, and accountability. On January 6th, a violent mob stormed the U.S. Capitol, seeking to overturn the lawful results of the 2020 presidential election. The mob's efforts disrupted and delayed the peaceful transfer of power for the first time in American history. The framers of the post-Civil War amendments to the U.S. Constitution understood that those who seek to overthrow the government should not be permitted to run it. That is why they adopted Section 3 of the 14th Amendment, which provides that no individual who engages in insurrection or rebellion against the Constitution after having previously taken an oath to support it shall hold any federal or state office. Although Section 3 was written to address post-Civil War challenges, its words are applicable today. This past September, in a case that Crew brought on behalf of a group of New Mexico residents, a New Mexico judge removed a county commissioner from office for engaging in insurrection in violation of Section 3. That ruling, the first in over 150 years removing someone from office under the 14th Amendment, explained that the events on and before January 6th were an insurrection. Section 3 is a crucial tool for securing our democracy, but it is not without limitations. SB 244, by its very terms, does two important things. First, it makes anyone who engages in rebellion or insurrection permanently ineligible to hold office in Connecticut or served in the armed forces, regardless of whether they previously swore an oath to the Constitution. Second, it makes anyone convicted of rebellion, insurrection, or seditious conspiracy or felony in relation to any such act permanently ineligible to be employed by the state or any of its political subdivisions. This legislation would more completely capture the individuals who attacked the U.S. Capitol and prohibit them from trying to run the government that they attempted to overthrow without inadvertently sweeping in protected First Amendment conduct. This is because the prohibition would still be tied to the existence of an insurrection, rebellion, or sedition, and therefore could not be weaponized against legitimate protest activity. In closing, to date, over 900 individuals who participated in the January 6th attack have been charged. In Connecticut, 5 individuals have been charged, pled guilty, or been convicted of felonies related to the attack. Moreover, others may be under investigation but have yet to face charges, such as Gino D. Giovanni Jr., a Derby alderman who this week filed paperwork to run for mayor despite having admitted to storming the Capitol. The fact that individuals who participated in the Capitol attack continue to serve in the government throughout the country represents an acute threat to our democracy. We strongly urge you to pass SB 244 during this legislative session. Thank you.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Representative Blumenthal.
Thank you, Madam Chair, and thank you for your testimony, Ms. Grandi. I was wondering if, from your perspective, there were any legal obstacles, constitutional or otherwise, that you're aware of to us expanding the provisions of the bill to cover not only individuals who previously sworn an oath to defend the Constitution of the United States to all persons. Are you aware of any legal obstacles to doing that?
Well, I am not a lawyer, so I'm happy to take your questions back to our team and get in touch with you and put you in touch with our legal team to get a more complete answer. But to my knowledge, no.
Okay. And I take your point on that. There is a certain logic not to limiting it to people who've previously sworn an oath only. And I think I thought your point with regard to timing is also significant. Criminal prosecutions often can take a significant amount of time. There's a statute of limitations. The investigations can sometimes take time, and sometimes we find individuals later on who either haven't been prosecuted yet, but may still be prosecuted, but maybe they're not even found out within the statute of limitations for the crime they committed. So maybe they never get prosecuted. So it makes sense to a certain extent to have, if we're going to do a bill like this, to have an adjudication independent of criminal prosecution to cover those individuals. And you're free to respond to that, but I guess there was no question mark really necessarily at the end of that statement.
No, I think you covered it.
Well, thank you, Madam Chair.
Thank you, Representative. Seeing no further questions or comments from members of the committee, thank you again for your time and your testimony today. We hope you have a nice weekend.
Thank you so much.
Next, we will hear from Evelise Carrera. And if I'm saying your name wrong, you've been generously participating in our hearings in the past, so please correct me so I can finally get it right. Anna Post.
At least you said it ye instead of Ivelise, so thank you.
Oh, well, that's good. Well, Evelise, the floor will be yours in just a moment. And after you speak, we will hear from Anna Posniak, who will be followed by Joe Toner. Welcome. The floor is yours.
Okay, thank you. I'll be speaking on 3 bills today. First regarding, here we go. Sorry. So first regarding HR 8, an act recognizing that all land was once Native American territory, as a Taino descendant myself, I do appreciate this resolution, but feel it does not go far enough. I would appreciate if lawmakers took a look at the side of the building they currently sit in. If you look on the side where it faces the Bushnell, you'll actually see John Mason leading the Pequot massacre. So I would ask that we go further than this recognition and maybe add a bust of John Brown, Walter S. Miller, or others to the Capitol in the same way we just added a bust of Ella Grasso. Next, regarding SB 1188, an act concerning, well, foreign spending. No foreign money should be allowed in American elections at any level. I would also like the committee to go forward and ban corporate spending as well. We should give the government back to the people instead of the highest donors. And finally, SB 244, which I originally was not going to speak on. I support this bill. However, the mention of Puerto Rican nationalists on the attempted assassination of Truman, I did have to correct a couple facts. They never entered the Capitol building, but were outside the Blair House during the renovation of the White House. Puerto Rico was colonized just like Hawaii and only given citizenship because it would allow us to be drafted in World War I. We endured military occupation of our homeland since the 1800s. Between bombing Vieques and being used as a domestic tax shelter while currently being held under the Jones Act. Further oppression led to the 1983 Wells Fargo heist as the movement for Puerto Rican freedom continues. If Puerto Rico were not a U.S. colony, the actions of the U.S. government would be considered war crimes. And that is it. I was wondering if the committee had any questions for me. And also shout out to my uncle who did die at the hands of the FBI regarding these actions. Filiberto Ojeda Rios.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. We hope you have a nice weekend.
Thank you. Enjoy your weekend. Bye.
Bye-bye. Next, we will hear from Anna Posniak, who will be followed by Joe Toner, who will be followed by Chris Prue. Welcome, Anna. The floor is yours.
Good afternoon, Senator Flexer, Representative Blumenthal, and the distinguished members of the GAE committee. My name is Anna Posniak. I am the Windsor Town Clerk and co-chair of the Legislative Committee for the Connecticut Town Clerks Association. First, I would like to address SB 1189, an act concerning the deadline for filing nominating petitions with the Secretary of the State. Currently, petitions are filed either with the town clerk or the Secretary of the State. The Secretary receives a vast number of the nominating petitions in the days leading up to the deadline. These last-minute filings have presented a challenge for the Secretary's office with the need to sort a large number of the petitions first by town, then track the number of pages and print a report to attach to each package, which will then be mailed to the respective town clerks by regular first-class mail. Upon receipt of the pages, the town clerks must verify each signature and certify the total number of valid signatories. The petitions are then mailed back to the Secretary of State, who must further determine if petitioning candidate has met the qualifications to appear on the ballot. In recent years, due to postal delays, there have been instances of the town clerk not receiving the packet from the secretary for a week or more past the statutory deadline for town clerks to return the certified petitions back to the secretary. As you may have concluded, there are numerous steps for a candidate to qualify for a ballot, and the postal delays are impeding upon the success of a candidate to be on the ballot and impacting the tight election calendar. Secretary Thomas, in her written testimony, stated she supported an alternate bill as well to take the secretary out of the process of transmitting the petitions. The CTCA supports either options of an earlier deadline or removing the secretary from the process, as this recommended change with filing the nominating petitions will ensure the timely preparation and printing of absentee ballots to meet the statutory requirement of issuing absentee ballots 31 days before an election. Lastly, I'd like to speak to HB 68070, which is an act concerning retrieval of absentee ballots by town clerks in the drop boxes. Absentee ballot drop boxes have proven to be a convenience for our voters and have successfully reduced our rejection rate for the ballots. This bill addresses a technical issue with the current statute 9-140B that presently requires town clerks to retrieve absentee ballots from the drop boxes beginning 29 days before each election, primary, or referendum. Currently, absentee ballots are issued 31 days before an election, 21 days before a primary, or 19 days before a referendum. With absentee ballots issued at a later time frame for primaries and referendums, we are requesting a technical change to better align the retrieval of ballots with the actual first day absentee ballots are issued by town clerks. Thank you for this opportunity to testify regarding enhancing our elections in Connecticut.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. We hope you have a nice weekend.
Thank you, too.
Next, we will hear from Joe Toner, who will be followed by Chris Prue, who will be followed by Tim DiCarlo. Joe, welcome. The floor is yours.
Thank you, Madam Chair. Chairman Blumenthal, members of the committee. My name is Joe Toner. I'm the Executive Director of Connecticut State Building Trades, representing over 30,000 hardworking men and women in the unionized construction industry. And I'm here today to strongly oppose SB 1184, an act implementing and recommendations of the Department of Administrative Services concerning state contracting requirements and certain procurement thresholds. And the piece in that legislation that we strongly oppose is increasing the thresholds to be pre-qualified from $500,000 to $1 million. What I'll say, I don't think, I try to be polite to say this, but I don't think now is the time to lower standards in the construction industry when the folks from DAS and the Office of School Construction have federal investigators in the state of Connecticut right now investigating wrongful doing. So that being said, and I hate to put it that bluntly, but that's how serious it is, and that's the truth behind it. So let's get into the non-DAS or the pre-qualification on the DAS packages from $500,000 to $1 million. So currently, if you're going to do work on a public project and you receive a contract under $500,000, that also means you don't have to provide a bid. There's no bid bond on that work. So what that means is it's a lower level. The people reapply every year. The construction companies reapply every year. And at that time, if they're deemed that they could do more work, then they become DAS certified, right? Pre-qualified to do the work. There's over 2,700 construction companies that are DAS certified. So it's not a high mark. The qualification is the barometer of what has to be done in the construction industry. So if these folks are not posting bonds and they cannot certify yearly to become DAS certified, what makes people think that if they can't certify to do $500,000 of work, they could do $1 million worth of work? It's ludicrous. It truly is. Not having a bond in place causes a lot of problems. It shifts liability to a lot of people. It's going to shift liability to the municipality, the state of Connecticut. It's going to shift the liability to the construction managers. And most of all, I think this wasn't even, we discussed when we talked to DAS, is the workers are going to be harmed. There's going to be no bond for the Department of Labor to come back and try to recoup those monies for the people. And when contractors start going sideways and they're having problems financially, the first people at harm are the workers. So to double down and give people work that they can't currently qualify for is dangerous. And if I could, Chairman, I'd like a quick analogy, because a lot of times people think the construction industry, there's a mystery behind it. But if you're in the pool on a hot summer day and you're in the 3-foot section of the pool on your tiptoes, you're doing pretty good, right? You're enjoying the water, you're staying out of the sun. I don't think it's a good idea to take that same person and dump them into the 6-foot end of the pool without giving them a swimming lesson, right? And that's typically what this truly is going to do. So we stand in opposition, and I would take any questions at this time.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions from members of the committee? Seeing none, thank you again for your testimony, and we hope you have a nice weekend. Next, we will hear from Chris Prue, who will be followed by Tim DiCarlo, who will be followed by Mary O'Brien. Welcome, Chris. I believe you're online. The floor is yours.
Thank you, Senator Flexer, Representative Blumenthal, members of the GAE committee. My name is Chris Prue, and I am the Democratic Registrar for the town of Vernon and the president of the Registrars and Voters Association of Connecticut. I've submitted testimony already, so I will just summarize a little bit. The ROVAC is in opposition to Senate Bill 1190, an act concerning regional election advisors and a task force on election administration in municipalities. This bill, in essence, duplicates what ROVAC and the Secretary of the State's office already do. When this program first began, this position was filled in most COGs, but over time, as you've heard previous testimony, these positions have dwindled to where it is today. In fact, some councils, the COG monitors were hired, but registrars, such as myself and numerous others around the state, I never even knew the name of our monitor or received any support from them. And I know that's not across the board, but also I think it's important to note that the authority of the regional monitors in current legislation is quite narrow. The main purpose of this position, according to the current legislation, is simply to help towns coordinate moderator training. Moderator training is provided by the Secretary of the State's approved and trained instructors. Each moderator must take a mandatory class, pass a certification exam, in addition to other required online training prescribed by the Secretary of State's office. Historically, training new registrars and other training that you've heard about today were completed at the Secretary of the State's office. And so again, I've submitted testimony, so I thank you for the opportunity to testify before you today. ROVAC is committed to working to strengthen elections in Connecticut. So I will take any questions if there are any.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? I do have one question, seeing none from the other members. In preparation for your testimony on this bill today, did you speak with any registrars of voters in Windham County?
I have spoken to numerous, and there are 2 regional election monitors that are very active in Connecticut. Your county has one, or Windham County, excuse me. Windham County has one that is still quite active, and her and I have even spoke about the issues that arise with regional election monitors and the ways that they are currently helping registrars. But again, I just wanted to clarify that the only authority that they really had was in moderator training, and I know that this would change things. And I would see the program in a different way, I guess, maybe.
Thank you. The person you're referencing, that's a registrar you spoke with, you said? I'm sorry, I couldn't quite hear you.
Yes, there is a registrar. There's several registrars. I talk to many of them around the state often, but I did talk to even the county chair in Windham County, as well as the regional monitor in that county.
Thank you. And as a follow-up, what support did ROVAC as an organization provide to the town of Sterling when they had almost no registrar of voters?
Well, in the state, the registrars of voters are led by their county chairs first. So the county chairs are the first line of education and support for ROVAC. And they're responsible for reaching out to the leaders of ROVAC in order to get additional help. And so not being brought to my attention, I wasn't able to help with that town. So I can't say that, ROVAC overall, but the county chairs and the county organizations are the first line to assist in a town that needs assistance.
That's helpful to know, but you can't speak to whether or not there was any assistance given in that situation?
Not that particular one, no.
Okay, thank you. Seeing no other questions or comments, thank you again for your time and your testimony. I hope you have a nice weekend.
Thank you, as well.
Next, we will hear from Tim DiCarlo, who will be followed by Mary O'Brien, who will be followed by Ann Spire. Welcome, Tim. The floor is yours.
Thank you. Senator Flexer, Representative Blumenthal, Ranking Members Sampson and Master Francesco, and members of the GAE committee. My name is Timothy DiCarlo. I'm the Registrar of Voters for the City of Waterbury, the chair of the New Haven County Registrar of Voters Association, as well as the chair of the Legislative Committee for ROVAC. ROVAC is here in opposition of House Bill 6871. This bill, as proposed, would make several changes that would negatively impact the way in which election recanvasses are currently administered. This legislation in lines 15 through 19 would require registrars to use one voting tabulator per district when conducting a recanvass of an election. ROVAC opposes this change to the existing law. Currently, registrars can use the same tabulator for several districts in order to conduct a recanvass. After one district has been successfully recanvassed, the registrar can remove the memory card from the tabulator, insert a new memory card that contains pre-programmed data for the next district, and be able to recanvass that new district. Memory cards are changed in the view of the public, and a zero tape, which is printed, shows that no votes existed prior to the new recanvass taking place. Currently, towns have 2 tabulators per district on hand. After the election, the tabulators which is used in the election is sealed and impounded for a total of 14 days. It must be determined within 3 days after an election if a recanvass must be conducted. The backup tabulator would need to be used in order to conduct the recanvass. However, there are many times in which the backup tabulator was used during the election, leaving both tabulators for the district impounded. Connecticut began using the AccuVote OS tabulators in 2006. At a time, each municipality received 2 tabulators per district. In 2006, Connecticut held 2 reapportionment. Since 2006, Connecticut has held 2 reapportionment committees in 2011 and 2021 for the purpose of redistricting the state for federal districts and state districts. Many municipalities in Connecticut no longer have the same voting districts that they had in 2011 or 2021. Although the state purchased 100 tabulators recently, many municipalities are left having to borrow tabulators from other towns when conducting a recanvass. This is due to a lack of tabulators available in their town. Removing this option of allowing registrars to reuse a tabulator for recanvass will cause some towns to have to locate and acquire tabulators from another in order to conduct a recanvass. This is an unnecessary requirement that ROVAC respectfully asks the committee to reject this change. There are simply not enough tabulators available at this time and statewide. And moving on, ROVAC would also urge the committee to reject the changes in line 101 through 103, as these lines introduce party politics into the recanvass. Currently, those assigned to work the recanvass in the case of a primary election or opposing factions of a general election are from each major party. The general public has always been allowed to observe a recanvass. However, they are not allowed to interrupt the process. Lines 101 through 103 would allow the party representatives to view each ballot that is being recanvassed. This change would drastically slow down the recanvass. More importantly, the parties are already represented by those who are conducting a recanvass. This change would only introduce disorder in the current process, and ROVAC would ask the committee to oppose this section as written. The current AccuVote OS tabulators are at the end of their lifespan and need to be replaced in the near future. ROVAC would ask the committee to wait until a new ballot marking system is chosen by the Secretary of State before making changes to the recanvass procedures. It is highly likely that an entire new process for recanvassing will be needed in order to conduct recanvasses in the future.
Thank you. I'm sorry to interrupt. Your time is finished. Would you mind summarizing?
I'm sorry, I didn't hear the bell, but I am set. Thank you.
Okay, thank you. Thank you very much for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you very much. Have a nice weekend.
You as well.
Next, we will hear from Mary O'Brien, who will be followed by Ann Spire, who will be followed by John McNamara. Welcome, Mary. The floor is yours.
Am I supposed to press a button? No.
Nope, you're all set. It's on. Thank you.
I'm Mary O'Brien from New Britain. I am the president of the New Britain Area League of Women Voters. However, this is my personal testimony in support of SB 862, an act concerning clarity and simplicity of referendum questions. I thank the committee for this privilege. Last summer and fall, the New Britain Area League of Women Voters spent many days outside of Stop and Shop, registering voters and offering information on the charter revision ballot questions. A high percentage of people who came by took our flyers and said yes, they wanted to know about the ballot questions. They knew there would be questions to vote on, but had no idea what the questions would be. After seeing the questions, two very clear reactions happened time after time. One was from people who supported one part of the changes, but opposed another. They were frustrated upon learning that they could not vote for part of the question one way and part another way. Another reaction was anger that the city was trying to put something over on them because the changes mattered and they had not heard about any of it. Personally, I felt as a conscientious and committed voter that I was being disrespected because 5 questions on the ballot were lumped into one without being explained. While legal notice of the content of the ballot is already required, it is published in the classifieds of the local newspapers. This is an outdated form of notice, and local papers are becoming a rarity. This increases the need for separation of issues for overall clarity in ballot questions for charter revision. When voters enter the ballot booth and read the ballot, they should be able to read the questions and know what they pertain to. A number of times we heard, is this even legal? There should be a law. And so, being the League of Women Voters, we studied and discussed, acted, and we met with our legislative delegation, and SB 862 was the outcome. We support SB 862 as a solution to this issue. It will require that each ballot question be specific to one subject, each question be explanatory as to the proposed changes. There will be requirements of clear, plain language for questions. And up for discussion is that each ballot question be reviewed and approved by the Secretary of State. If it does not meet the standard for clarity, it will be returned to the issuing body for a revision in a timely fashion. Thank you.
Nice timing. Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. We hope you have a nice weekend.
Thank you.
Next, we will hear from Ann Spire, who will be followed by John McNamara, who will be followed by Luther Weeks. Welcome, Ann. The floor is yours.
Thank you. Good afternoon, Senator Flexer, Representative Blumenthal, and Representative Hosa. Thank you for being here and listening. I'm Ann Spire. I'm speaking on behalf of the League of Women Voters New Britain area in strong support of SB 862, an act concerning clarity and simplicity of referendum questions. 2 comments before I begin to talk about the need for this bill. When we presented this concept originally, we had asked for clarifying language in ballot questions regarding charter revision referendum, not all referendum. Clear language in charter revision questions remains our focus. And secondly, we've been following the submitted testimony, and most of it has been quite supportive of the concept, but we're also aware of the concerns of the Secretary of State about the review process and some people on the town clerk's group. If there is a need for further discussion of this, let's talk, let's have that discussion. But let's get this bill moving, which has so much support, so that we can have it happen. At the last election, New Britain ballot contained 2 charter revision questions. The first pertained to the structure of the Common Council, and it was specific in its proposal. Good. The second, though, told nothing to the voters about its impact. It read, shall the remainder of changes to the city charter as recommended by the Charter Revision Commission be approved? It gave no hints. This question implied that the changes were not substantive. This was not the case. They included changing the offices of town clerk and tax collector from elected to appointed offices. The new position of a COO, a hired city manager, given much of the same authority as the mayor, but not elected. The independent water department moved into part of public works. Boards and commissions were disbanded or merged, and there were other changes. Whether voters agreed or disagreed about these changes isn't the point. The point is they were substantive issues. They should have been clearly spelled out to the voters so they knew what they were talking about. The other thing that we found is that many of the people, as Mary said, who's responded when we're out lobbying, said, wait a minute, I like that. I don't like that. What am I supposed to do about that? They're very frustrated about that. It's not the way the law should be functioning. It's not the way elections should function. So we formed our committee, we talked, we met, we looked at things, and then we met with our legislative delegates, Rick Lopes, Bobby Sanchez, Manny Sanchez, Peter Terziak, and Gary Turco. They're all in strong support and they put this forward. Coincidentally, both Newington and New Britain had the same problem. So Gary's involvement in both, he's got a double whammy. They agreed that a bill needed to go forward to cure the problem, and they are the sponsors of this bill. Wrapping up, I just wanted to mention that the League of Women Voters has supported informed voters as the bedrock of democracy in our work for over 100 years. We distribute nonpartisan information and run many forums as part of that work. We believe SB 862 will serve to safeguard the needs of voters to be informed on referendum ballot questions. Therefore, we strongly urge its passage. Thank you. Questions?
Thank you. Thank you for your time and your testimony this afternoon. We have a question from Representative Blumenthal.
Okay.
Thank you, Madam Chair, and thank you for your testimony. That is profoundly disturbing, to say the least, what you've described in terms of the process. And we appreciate it, you bringing the story to us. I guess I just wanted to clarify your position. In the beginning, you said that your focus was on charter revisions.
Yes.
Is it that you object to this bill covering things other than charter revisions, or that you just, that's your number one priority?
We had started out in response to a charter revision issue. I don't know if there are problems with applying the same requirements to other financial referendums. If it asks that we want to pass a budget of $5 million, but it doesn't specify the line items, is that going to have a problem? I don't know, that you guys have more staff than we do. So, but we wanted you to know that we were looking at charter revision, and it's a problem all around the state from what we could find. We've heard from other towns as well.
Well, thank you. We appreciate it. You know, my city, Stanford, is going through the charter revision process right now. So certainly timely for a lot of places throughout the state. And we appreciate your testimony.
Okay,
thank you very much.
Seeing no further questions or, oh, no, I'm sorry. Mary, Ann, can you please come back?
I am not.
There was another question or comment from a member of the committee. So thank you for rejoining us. Representative Hoxa.
Sure.
Thank you, Madam Chair, and through you. Thank you, ma'am, for coming before us today. I appreciate your testimony. My question to you is, is it your position that there is no other way to obtain the information required to make an educated vote on these, referendum items on your ballot, other than those items being specifically elaborated on the ballot itself? Is there an alternative way to obtain information on what you are voting on? Because what I'm trying to get at is that sometimes, charter revision items can be really long as far as what the new content being implemented is. So just as a matter of just as a practical matter, if there's a lot, they may not fit on a ballot. All of them may not be able to fit on a ballot. So I believe the lady that spoke before you mentioned something along the lines of it being, published in the classified section, which I understand, is, a kind of an antiquated way of, I wouldn't look there, right? But are there any other ways to obtain this information?
Okay, I understand your question. Yeah, it gets published in the classifieds, and I'm probably one of the few public activist geeks who actually saw that, because I actually got the Herald at the time. However, the number of people who were reached by that is minuscule. The city gave a one-sided talk, the Charter Revision Committee people gave a one-sided talk on what was on it, in that others, people who were in opposition, I wasn't involved in this, but you asked, so I'll give you some background. There's a session at the public library, but I know that those who were in opposition to it were not allowed into that session because the Charter Revision said, no, this is our meeting, we're going to hold it. That's pretty limited. Most people, though, and what struck us is we were at Stop and Shop and we were at America's Food Basket over on Allen Street and at Seatown doing basically voter registration when we gave out information on the flyer, on the Charter Revision. 90%, 95% of people had no idea, A, there were ballot questions. Somebody asked me, can I sign it here? The lack of knowledge was enormous. If they knew there might be a question, they knew that early voting might be out there because there was enough stuff, publicity out there on that. They didn't know anything about city charter questions coming up, though. Awful lot of people really don't know what the city charter does, which if I weren't me, I probably wouldn't either. There's a real need for it to at least be clear to the extent of, do you support the hiring of a COO? End of question. Do you support putting the water department into public works? Question. Do you appoint making the tax collector and town clerk appointed officers civil service? End of question. I think it can be done. Other towns have done it. So other states have it too, I gather. I think John McNamara may have more to say on that. He was researching that. I wasn't. Does that help?
Thank you. Yeah, no, thank you for providing those examples.
Yeah.
Just as a really quick follow-up to that. So it is your position that on the ballot, this past election, when those items were on there, they were all kind of grouped into one question and they were not listed the way you said.
They were all listed into, shall the remainder of the changes to the city charter as recommended by the Charter Revision Commission be approved? That's all that voters saw. And they had just seen a really nice specific program about going to wards instead of at large in wards, the way the council is structured. So I think a lot of people, from what I'm hearing, figured, well, that's the specific stuff that really has an impact. And then this is just the make all the grammar work, the he, she stuff, correcting and updating, etc. Because it was paired with the other.
Thank you for that.
Thank you, Representative.
Anything else?
Seeing no further comments or questions, thank you again for your time and your testimony. We hope you have a nice
Absolutely.
weekend.
We'll be around. We're in New Britain, not very far if you need us again.
Good to know. Thank you. Next, we will hear from John McNamara, who will be followed by Luther Weeks, who will be followed by Kimberly Glassman. Welcome, John. The floor is yours.
Hello, Senator Flexer, and thanks to you, Representative Blumenthal, Representative Mastro Francesco, and Senator Sampson, and all the members of the committee. I also support Senate Bill 862 that will, as it says, provide clarity and simplicity on municipal referendum questions. I think it'll provide municipal authorities with clarity too and direction they need to ensure that important ballot questions are neither vague nor misleading and give voters sufficient information in the voting booth to know what they're voting on. My good neighbors from New Britain, from the League, have told you what the issue was in New Britain. I think it's a case study in why the law needs to change. Specificity is essential when charter changes involve a significant increase in costs to the taxpayers, which combined the multi-issue question all in one question did. As a voter who favored an appointed tax collector and town clerk, but opposed a full-time city manager, along with a full-time mayor, I was disenfranchised last year. One supporter in favor of all those changes was even moved to write a letter to the editor saying the catch-all question was wrong, and a third question would have given the voters a greater level of transparency. In adopting the catch-all question that you've heard about, the Common Council accepted the commission's recommendations without amendment, but dissed the commission. The commission has stipulated there be 2 additional questions for the sake of transparency after their 6 months of hearings and deliberations. They were ignored. And a final point is that you'll find that 17 states have dealt with this issue in their initiatives and referendums by mandating a single subject rule. The rule mainly applies to statewide referendum, but some states, such as Oregon, make it apply to municipal and town referendums. Making a single subject rule, or in the language of this bill before you, one subject matter, can avoid controversy, can head off lawsuits, and as one state Supreme Court found, allow greater voter representation because there's no ambiguity regarding the intention of each voter when they cast a vote. Parenthetically, I think you may want to look at the warning that's stipulated in the current statute. The warning in New Britain for these questions contained no information about the substance of question 3 that's at issue. And I think you can find in other testimony from the State League of Women Voters and others more information about why a change in the law is needed. So in considering the bill, there's plenty of precedent for you to act on it. In the words of Senator Lopes, who co-sponsored it, the bill makes common sense, and it's in the interest of transparency and voters' rights to know. So I urge a favorable report on 862. Thank you.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you.
Madam Chair.
Yep, Representative Santiago, the floor is yours.
Thank you. Thank you. I didn't have time to raise my hand. Thank you, Mr. McNamara, for being in today. I just have a couple of questions. Who has the authority to change the wording on the charter?
The final wording rests with the city council. The council, I might add that the commission presented their recommendations for action by the council 30 days before the council acted at it at probably the last meeting they could at the end of June last year. And I know there's been concerns by our town clerk about the calendar and so on and so forth. I think that's a doable thing to have oversight by it. I don't think it's an budget impact on the Secretary of the State either. So it is the legislative branch, Representative Santiago.
Okay, and then I have one quick question. I'm just curious about it. I know that in New Britain, you have a large Polish population, a large Hispanic population. So is that when they do the referendums, are they also in those languages? I was just curious.
I believe it was at least bilingual with regard to Spanish and English. And I could be wrong. It could have been in Polish as well. And certainly supporting candidates, we need phone bankers who speak all 3. But I would say it was. Absentee voters got a 7-point summary of the changes when they received their ballots. And as you know, there are postings in each polling place that nobody looks at. So I just urge you to look at other states that have the single subject rule. And I think you'll find this has merit.
Okay, great. I mean, I support the bill that was put forward, and I think you're correct. I think we need more transparency. So thank you for being here today, and thank you for being able to testify. Thank you, Madam Chair.
Good to see you. Thanks.
Thank you. Thank you, Representative. Seeing no further comments or questions, thank you again for your time and your testimony. We hope you have a nice weekend.
Thank you very much.
Next, we will hear from Luther Weeks, who will be followed by Kimberly Glassman, who will be followed by Laura Smits. Welcome, Luther. The floor is yours.
Chairs and members of the committee, my name is Luther Weeks from Glastonbury. I am a certified moderator and election day official since 2008. I have observed about a half dozen recanvasses from a distance and officially represented candidates and referendum advocates in 7 recanvasses. On HB 6870, a common error in Connecticut law is not requiring 2 officials when handling and transporting ballots, absentee ballot applications, and absentee ballot envelopes. When emptying drop boxes, 2 officials should open the boxes and transport them to secure storage in the municipal clerk's vault. Both should sign a log with the date, time, and location of the drop box. The log should list the materials retrieved by type. Better still, the same procedures should apply to all transport of ballots, application materials, and registration forms by the clerk's office and registrar's office. Turning to HB 6871, the number of tabulators required should include 1 for each central count location, plus at least 1 spare for each 3 or less polling place and counting locations. I agree with Secretary Thomas that this portion of the law should be delayed until 2025. For several reasons, new tabulators should be implemented no earlier than 2025. When we select and implement new tabulators, we will likely need 2 or 3 tabulators or more in many polling places because they're much slower than the ones we have today. Section 2, nothing is sadder for me than to watch from the sidelines as recanvass procedures are not followed and no party or candidate observers understand the process well enough to recognize which procedures are not being followed. The recanvass for procedure video should be made available to the public and a link to it provided for each notice of a recanvass. The act does not recognize that for primaries, there are generally no opposing party officials available for recanvass. Section 3A1 should specify that the absentee ballot applications and moderators' returns brought to the recanvass be open to public inspection at the recanvass. Notice should not just be given to party chairs, but also to every candidate in a race to be recanvassed. Notice my written testimony, I didn't write the word "not" in there. I don't know how I dropped that. At a recanvass, each party candidate or referendum should be allowed a minimum of 1 observer for each counting team for ballot or envelope counting. In several places, tabulators, absentee ballots, and write-in ballots are mentioned. However, all such references should cover all ballots, whether polling place or centrally counted, including originally hand-counted, early voting, election day registration, or same-day registration ballots.
If you could just summarize the remainder.
Yeah, I'm all done.
All right.
That was the last line I had.
Okay, well, appreciate it, Mr. Weeks. Other questions from the committee? I had one, and you may have answered it because I just missed part of the beginning of your testimony.
Sure.
There was a point about recanvasses with regard to primaries and the lack of availability of officials of both parties.
No, well,
If you
yeah, that's correct because
you just rephrase that concern.
yeah, well, it maybe should say opposing interest, officials of opposing interest, if you can find them, because there's only 1 party running a primary. Now, if we have 2 primaries going on at the same time, then you have election officials that serve from both parties that you would have do that. I'll just mention I have a few more details in my written testimony and all these things.
Okay, I'll be sure to review that. I guess my one question on that would be, if the bill didn't include primaries, then would that resolve the concern, or would there still be a concern there?
Yeah, well, it shouldn't be just parties. It should be independent candidates as well.
I see.
So in our town last year, we had 2 parties, but we had 1 candidate that was unaffiliated. He wasn't involved in a recanvass, but he deserves notice. So I think every candidate should be notified, even if they are a member of a party.
I understand. Appreciate it. The answers to my question.
Okay.
Any further questions
Great.
from the committee? Seeing none,
Thank you.
Appreciate your testimony.
Yeah, I gotta run
Great
off to
weekend.
another committee now.
Good luck. Next up, we have Kimberly Glassman, followed by Laura Smits, followed by Amanuski. Is Ms. Glassman with us?
Yes, hi.
Sorry, virtual.
I'm remote.
Whenever you're ready, you are clear for takeoff.
Thank you. Thank you, Chairman Blumenthal, Chairwoman Flexer, Ranking Member Sampson, Ranking Member Master Francesco, and the members of the Government Administration and Elections Committee. My name is Kimberly Glassman. I'm the director of the Foundation for Fair Contracting of Connecticut. You did hear from my colleague earlier this afternoon, Joe Toner, who is the executive director of the Connecticut State Building Trades Council, and a number of my affiliates, both from labor as well as a number of contractor associations, have submitted testimony on Senate Bill 1184, as have I. That bill is entitled, got my testimony up, multiple computers. So I apologize. An act implementing the recommendations of the Department of Administrative Services concerning state contracting requirements and certain procurement thresholds. I did submit written testimony. I will not read it verbatim. I will just summarize. My organization has concerns with the section of this bill that specifically recommends increasing the threshold for pre-qualification from $500,000 to $1 million. And specifically, we think that this is important to this committee because we worked very hard with this committee beginning in 2019 to bring more transparency to the pre-qualification application. This committee unanimously supported including in the pre-qualification application any adjudicated wage theft cases which had not been included in the pre-qualification application previously. Then there was a working group that was formed, and that working group submitted a report to the legislature in January of 2020 that made further recommendations on the pre-qualification application, which this committee and the legislature adopted last year, which now includes additional oversight in the pre-qualification application, asking that contractors applying for pre-qualification include a 5-year look back of any settled wage theft cases with the Connecticut Department of Labor, including any stop work cases that have been filed against them and any civil penalties assessed against them as well. And now that is finally in effect, that is now the law of the land. And now it feels like, and I know that's not the intention of this agency, but it feels like the goalposts are moving. We finally have this additional transparency on wage theft on our state contractors, and the goalpost is moving with an increase in the threshold. What I've heard from the agency is that this is in keeping with the rate of inflation, and that the pre-qualification, the reviewing of these pre-qualification applications is an administrative burden on the agency. We certainly have a lot of respect for what the Department of Administrative Services does. We've been working really well with this agency for many, many years and work very well with Commissioner Gilman, have a lot of respect for Commissioner Gilman and Deputy Commissioner Michael. And we would certainly be open to working with this agency to come up with a way to ease that administrative burden on the agency while still maintaining this high level of accountability and transparency on these contracts. We do not think this is the right time to increase this threshold. You're going to be removing a large swath of state contractors who will have to maintain this accountability, this transparency, and provide this wage theft or wage issues information to the state. We think it's really important. So we do hope that this committee please consider that with this legislation. And we ask that you please consider, if you're going to move Senate Bill 1184 forward, that you maybe consider maintaining the pre-qualification application threshold at 500,000 rather than moving it to 1 million. I'm going to see the rest of my time for any questions that any members of the committee have, and I thank you.
Thank you. Are there any questions from the committee? Seeing none, thank you very much, Ms. Glassman, for being with us today.
Thank you.
Next up is Laura Smits, followed by Amanuski, followed by Samuel Gold. Ms. Smits, welcome, and you may proceed whenever you're ready.
Thank you, Representative Blumenthal, Senator Flexer, Senator Sampson, Representative Mastro Francesco. My name is Laura Smith. I'm the president of the State League of Women Voters, and I'm here in support of SB 862. The League of Women Voters of Connecticut appreciates the opportunity to comment on this bill. The citizens' right to know and public participation are at the core of many of our positions. As the National League frames this, that we believe that democratic government depends upon informed and active participation at all levels of government. The League further believes that governmental bodies must protect the citizens' right to know by giving adequate notice of proposed actions, holding open meetings, and making public records accessible. Raise Bill SB 862 supports this principle in lines 24 through 29 in requiring clear, plain language in referendum questions. This is a good idea anytime in governmental documents, but because the bill proponents specifically seek to address problems in charter revision questions, the committee should also look at CGS sections 7 through 191, which includes charters, charter amendments, and home rule ordinance amendments. The problem. Charter reform can have serious impact on the structure and functioning of our city and town governments. Ballot questions which propose changes to a charter must be clearly stated to the voters. Unfortunately, the League has found that this is often not the case on many ballots. As my colleague Ann Spire recently mentioned, charter reform often consists of several unrelated issues lumped together into a single question described only as recommended changes of the Charter Revision Committee. Such summary questions fail to inform voters of all the changes themselves. To offer them a yes or no vote is not enough. Some of the issues buried within generalized questions are important. Board of Education terms, hiring of town managers, abolishing appeals boards, and changing town clerks and tax collectors from elected positions to appointed ones. Several municipalities have laid out their questions by individual topics so that voters had explicit information as to the issues being addressed, so it can be done. We support Raise Bill SB 862 as far as it goes. Explicitly requiring clear, plain language is good for any referendum question. Providing for a judge or standard to guide the town's framing ballot questions is also good. A failed state constitutional question in recent years is a good example of confusing language. A dedicated referendum election typically has a much lower turnout than a general election. In recent years, the town of, for example, the town of Orange tried for charter revision as a special referendum, but did not get 15% at the polls, which is the benchmark to do so. So it failed even with a majority approval. The 15% bar inclines towns to use a larger turnout occasion on a state or local election to get around that problem. That option also eliminates expenses for a special election, but the ballots for recurring voting machines have limited space for several ballot questions. We do not know why the current law allows for one or several questions. Let's assume the best, that a commission is not trying to fool the people. The option to pose one or several questions can lead them to save money on ballot printing since the law permits them to submit only one. Publicity of several proposed revisions can take also money and effort. But without that effort, without help from dying local newspapers and underfunded community access media, the voters end up believing the worst of charter revision proponents. Such efforts should not be wasted volunteer time by trying to save money on poorly framed ballot questions. Good information is necessary for good government. Thank you.
Thank you. Questions or comments from the committee? Representative Mastro Francesco.
Thank you, Mr. Chairman. Thank you. I've seen you sitting there all day waiting patiently, so I appreciate that. Thank you very much. So questions that go on the ballot for a municipality are always decided by the town.
Correct.
And have you seen a problem with the town putting that question? Like, are they limiting, are you experiencing certain towns limiting the information that they are putting on the ballot?
Yes, the problem is that the questions are usually very complex. And so because they are complex, they're not allowed that much space. And sometimes, as we've seen with the early voting question, for example, the length of the ballot question makes it difficult for people to understand what they're voting on. So it's been difficult to get all of the information. So just putting it all together in one question makes it difficult for people to understand what is in that question.
Right. And I understand that, having served on our town council, sometimes if there was a town with people were voting on a bond package and they were all different, everything is kind of lumped together.
Correct.
Where they could have put that on the ballot as separate. Should we go out to bond for this, this and that? And I think that's done strategically probably by the town, that they want it all because most people will support a piece of it and so forth. And I think that's done by design. But I also think that it's up to the town to make those decisions based on what their charter is. So are you saying that you would rather see the question go to the Secretary of State and the Secretary of State approve it, and to minimize how many words are in that?
Not necessarily,
Question?
just to make it so that the towns use plain language and are as clear as they can possibly be without it being too much legalese, which can confuse people. And
Right.
We have found that when people are confused, they tend not to vote at all, unfortunately, and that's.
Well,
not
and
good.
I know in other towns, they try to, maybe the questions long because they're really trying to give more information. Because sometimes it's worse when there's not enough information in there. People don't really know what they're voting on.
Correct.
Which was a contention we had with the early voting. We wanted to be more definitive. Exactly how many days are we talking about? So it's kind of broad. And I think that's the issue. When there's a real broad question there, that there's not enough detail in it. So I was just curious to get your perspective on that, but I don't have any further questions. I appreciate your testimony.
Thank you
you
very much.
Thank you, Mr. Chairman.
Thank you. Further questions from the committee? Senator Sampson, sorry.
Thank you, Mr. Chairman. Thank you for being here too and being so patient all day. Yeah, I'm very sympathetic to this situation based on some of our own experience with the state questions. I guess the problem really boils down to trying to figure out who is the right arbiter of this is the language that is fair and complete.
Mhm.
And I'm a little reluctant to suggest that we turn it over to another elected political, effectively partisan individual, especially someone that is not a resident of that town. But I don't know that I have a better answer either. So
Mm.
I'm just gonna wanted to have the short conversation to let you know that I'm contemplating this and trying to figure out if there is another mechanism that might also work. And I would encourage folks that are interested in this issue to think about that too. I think the number one focus ought to be on trying to find someone that is not a political party to be involved in the decision making, or it's got to be a panel of people that are not partisan in some way. Anyway, I don't know, or even a mechanism or a trigger to allow someone who feels aggrieved on a town level to challenge it and say, I don't believe the question's fair, and have an avenue to pursue to maybe get that corrected or changed. Just if you have a reaction to anything I'm saying,
No,
you're
totally-
welcome
I
to.
think part of the challenge is, especially when you come to things like charter revision, which are very complex. It's really important to find, especially when we're losing our local newspapers, where can folks get the information so that if we have a clear question on the ballot, they know what they're answering. So I think that's the bigger challenge, is how to make those complex questions more accessible to the voters so that they can make a decision that relates to their values. I think it's really difficult to get clear language when you have so much complexity and so much legalese that's necessary on some of these questions.
Yeah, definitely, especially when you're talking about a charter revision
Right.
issue, which could be a multitude of things. I mean, we were just talking about early voting. It was pretty straightforward
Right.
concept compared to God knows how many charter revision changes. So anyway, thank you very, very much for being here. Appreciate it. Thank you, Mr. Chairman.
Thank you.
Thank you. Seeing no further questions or comments. Thank you, Ms. Smits. Ann Manuski, are you with us? You are up, followed by Samuel Gold, followed by Kim Kennison. Ms. Manuski, whenever you're ready.
Yes, thank you, Representative Blumenthal. Chairman and members of the Government Administration and Elections Committee. The Connecticut Republican Assembly is an organization which has members and friends totaling over 500 Republicans and conservatives across the 8 counties of Connecticut. We stand firm in our principles and unalienable rights under the U.S. Constitution, as well as the rights and responsibilities within the Connecticut Constitution. I'm Ann Maneski, a 24-year resident of Connecticut, former licensed professional counselor, and current president of the Connecticut Republican Assembly. We currently are watching in real time a second review of the events that took place in Washington, D.C. on January 6, 2020. We are learning as to how the media has operated as to cherry pick certain information and provide it, as well as the special January 6 subcommittee, and finding it to be void of half the facts. We, the people of Connecticut and the country, are looking forward to the release of videos and current 2023 House Special Committee review of the entirety of the videos and supporting material evidence as to the actual events that took place that day. It appears as though it was a political attack on our country. So in regard to the act of sedition, or specifically seditious conspiracy, this is a federal offense under USC 15. I have the information in my actual testimony. So I am one who I believe that our CTRA would be very happy to have this as a law in the state of Connecticut, because if there are individuals who have actually conspired against our government and are found guilty, that they should be removed from office and they should not hold public office. Please vote yes on SB 244. Thank you.
Thank you, Ms. Moneski. Are there any questions or comments from the committee? Seeing none, we appreciate you being with us today and sharing your testimony.
Thank you. Have a good weekend.
You too. Next up, excuse me, is Sam Gold, followed by Kim Kennison, followed by Jean Burke. Mr. Gold, I see you on Zoom. Whenever you're ready, you can begin.
Yes, good afternoon. My name is Sam Gold. I'm Executive Director of the Lower Connecticut River Valley Council of Governments, also known as RiverCog. And I want to thank the honorable co-chairs, ranking members, and members of the committee for giving me the opportunity this afternoon to speak in support of Senate Bill 1190, an act concerning regional election advisors and a task force on election administration in municipalities. The requirement that regional council of governments provide support to local elections officials, moderators, registrars has been in statute since 2015. Initially, this program was funded by the Secretary of State's office, but funding lapsed and was not replaced. Nevertheless, RiverCog has continued to fund this program, not only because it's a statutory mandate on COGS, but also because our 17 member municipalities find great value in it. This bill does a number of important things. The first is it renames the regional election monitors regional election advisors. This new name more accurately reflects the role that the statutory mandate to provide advisory support. Second, this bill restores funding for this mandated COG program and will allow more COGs to participate in it. Third, it removes the statutory mandate from this program by changing it from a shall to a may. This will allow COGs and their member municipalities to decide if a regional election advisor program is of value to them and whether or not it should be implemented. Finally, this bill would create a task force to deal with the issues facing administration of elections in the state, particularly issues related to staffing shortages. The infrastructure of our democracy is basically reliant on volunteers, who in many towns get a meager stipend for their work. These volunteers are disproportionately older and less technologically savvy. RiverCog's regional election support has been a needed and helpful program, particularly to our small towns, and it is universally valued by our member municipalities and their CEOs. It has allowed for smoother transitions as registrar positions become vacant and new registrars and moderators need assistance. Although the Secretary of State's office and ROVAC provide support, guidance, and training to municipal officials, any additional resources such as the existing COG program are needed and appreciated. Finally, the proposed task force will benefit the state as there is continued struggle to find people for these municipal election positions, while at the same time there's a technological transition occurring. It is my understanding that the current generation of technology and reporting, which came about after the debacles of the 2000 election, is being phased out and new systems and equipment are being implemented. The COGs are here to support our members, and we believe this is a good time for not only greater support for our municipalities, but also for a task force to help guide this most important infrastructure in our democracy. This testimony has been submitted in writing to the committee, and I just want to understate again that RiverCog has been very lucky to have an excellent regional election monitor. Her name is Carol Conklin, and she has submitted her own testimony. And I also want to point out that we appreciate the Secretary of the State's support for this bill. So if the legislators have any questions for me, I'm happy to answer anything that you may ask. Thank you.
Thank you very much. And we appreciate you pointing us to the written testimony as well. Are there any questions for Mr. Cole from the committee? Seeing none, thanks for being with us and have a great weekend.
You too. Thank you.
Next up is Kim Kennison, followed by Jean Burke, followed by David Barkin. Is Ms. Kennison present? I am not seeing. Oh, there you are. All right. Whenever you're ready, you may begin. Kim Kennison, I see you remotely, but we cannot hear you. You appear to be unmuted. If you want, why don't you try logging off and logging on again? We'll have someone else testify and then you can jump in right after them. All right, next up is Jean Burke.
Good afternoon.
Have you ready? Good afternoon.
Senator Flexer, Representative Blumenthal, other members of the committee. My name is Jean Burke. I'm the Director of Procurement for the Department of Administrative Services. And I'm here today to speak in support of Senate Bill 1184 regarding some changes in procurement thresholds and some other operational efficiencies. I have previously submitted some testimony in support of the bill, so I won't read that to you today, but just point out that this continues the modernization efforts of legislation that's been passed in the last two sessions to promote efficiencies and a business-friendly environment in the state of Connecticut, and especially supports the interest of small women and minority-owned businesses. I would like to address that. I know that there's at least one provision that seems to have sparked some conversation, and that relates to the raising of the threshold for the pre-qualification for contractors. In making this request, we were very conscious of the important public policy that is in place and that is served by the pre-qualification process in terms of the checks that go into it. But we believe that there is a countervailing and more important public policy to be served by promoting the interests of those small minority and women-owned contractors, because one of the aspects of the pre-qualification process serves as a barrier to entry, and that's the bonding requirements. And we believe that raising that threshold will permit greater opportunities for those contractors. And this is in keeping with what I believe to be the original legislative intent when that threshold was established in 2004 at $500,000. Had it been raised to keep pace with inflation over the years, it would have been raised to approximately the $1 million level that we're requesting today. So we believe we're actually maintaining the intent and public policy of the pre-qualification process, while at the same time promoting the interests of these small minority women-owned contractors. And with that, I am available for any questions you might have.
Thank you for your testimony. Are there any questions or comments from the committee? Senator McCrory.
Thank you. I think you're doing great public policy. It's in line with what we should be doing. And I think this is a great opportunity to provide opportunity that. I look forward to reading the bill further and also adding any commentary or any other means that we can do to level the playing field and provide opportunities for those who have not had opportunities in this industry. So I look forward to working with you on this. And if we have to expand it and make it more inclusive and provide opportunities to people, I look forward to doing it. Thank you very much.
Thank you, Senator McCrory. Are there further questions or comments from the committee? Seeing none, appreciate you being with us, sharing your testimony.
Thank you.
All right, Ms. Kennison, why don't we try again?
Can you? Nope, you can't hear me.
Nope, we got you. You're good.
Oh,
loud and clear.
gosh, it did not sound like I was in there yet, so I apologize for that. Good afternoon. Senator Flexer and Representative Blumenthal and members, honorable members of the Governmental Administrative Election Committee. Thank you for this opportunity today to provide you with testimony on House Bill 6867. It's an act concerning competitive negotiation for specific state contracts and some procurement practices. I'm Kimberly Kennison. I'm the Executive Financial Officer at the Office of Policy and Management, and I have the privilege of overseeing the procurement policies, plans, and requests from state agencies to procure for purchase of service and personal service agreements. This bill today will help to streamline the procurement processes that are already in play and align the legal side of it with the actual practices. It broadens the definition of procurement negotiation beyond the standard request for proposal practice, and it will include other solicitations so that responsible entities will have an equal opportunity to be selected for state contracts, such as a request for qualifications and those federal grant competitions. This change is consistent with national best practices on competitive procurement, which encourages a variety of mechanisms to best suit the needs of the state agencies, providers, and their clients. Any new competitive procurement will remain subject to all existing procurement standards that are in place. The bill raises the minimum threshold from for PSA and POS contracts from $20,000 to $50,000, and this will then align OPM's threshold with the Department of Administrative Services procurement practices to establish a uniform contracting threshold for the entire state and eliminate a lot of confusion of us both having two different thresholds. This will also encourage greater competition for folks to then focus on the higher value contracts versus the small dollar contracts, which will then provide a greater impact and cost savings to this state. The bill will also focus on the threshold of $50,000 and remove that 1 year requirement that we would have to look at procurement if they extended more than 1 year for a $50,000 contract. It will remove the automatic approval for PSA and POS contracts so that it aligns with the existing practices of approval. It will also update the approval requirements so that procurement for auditing services conform with the existing practices. It will clarify the definition of procurement service contractors for those transportation contracts, such as busing contracts.
Ms.
And
Kennison, I'm sorry to
yes.
interrupt, but if you could just summarize the rest of your testimony.
Will do.
Your time limit. Thanks.
Thank you. Lastly, OPM offers to substitute some of the language that is in for consideration for the $50,000 threshold, as there is 2 sections in the statute, and we would like to combine it to one for some clarity. And also suggest that we change the start date to January 24th in order to implement these processes, as we will have to update the core financial system model when in the approval process. Thank you for the opportunity today to address this new bill, and look for consideration. If you have any questions, I'm here to answer them or at a later time.
Thank you very much. Are there any questions from the committee? Seeing none, thank you very much for being with us today, and have a great weekend.
Thank you.
Next up is our last witness, David Barkin. Closing us out, Mr. Barkin. Whenever you're ready, you can begin.
Thank you. Thank you. Glasses time. I'm here to testify Senate Bill 1183. So thank you, Senators Flexer, Representative Blumenthal, Senator Sampson, Representative Francesco, and other members of the Government Administration and Elections Committee. My name is David Barkin. I am Chief Architect for DAS Construction Services, as well as Director of Operational and Process Planning. I'm here specifically, and I have submitted written testimony, so I'm not going to reread that for you, but just talk about some of the highlights We are supporting an increase in the cost thresholds for both the military department and the constituent units of higher education, Connecticut State colleges and universities, from $2 million to $3 million to allow them to administer construction projects up to those new thresholds from $2 to $3 million. It's been some time since they were brought to the $2 million threshold. Both of these organizations have extensive project management and engineering experience on staff and are fully capable of administering the projects of those size. We did, in looking at the capacity of all the agencies, seek their various technical skills, and those two agencies in particular have these deep benches. We are not in support of the judicial branch increasing to 3 million. Just last year, they went from 1.25 million to $2 million. Their model is quite different, and they don't have that same deep bench as do the others. So I think the argument is a little different in their case in terms of increasing their statutory authority to self-administer work. Finally, I would like your support in changing the what's called the definition of a program to $750,000 from its current level of $500,000. That allows us to use competitive contracts that we've selected under qualifications-based selection for consulting engineers, architects, and other specialties, and be able to hire them up to this threshold without having to go to a formal project-specific advertisement. This greatly speeds our selection process, and we have pools of consultants that already meet these qualifications through a competitive process. Thank you very much. I'm here for any questions you may have.
Thank you. Any questions or comments from the committee? Seeing none, we appreciate your testimony. Seeing no further witnesses,